Good morning, everyone.
Morning. I think we're about live here. So Darlene will let us know when we can start in 1 minute. Okay, I think we can start. Good morning, everyone.
Morning.
This is the May 31, 2022 meeting of the Board of Land and Natural Resources. This is a special meeting. The regular meeting had to be canceled due to a fairly simple technical violation of the Sunshine Law, which was that we neglected to properly save the agenda on the state website, even though it was posted on the DLNR website. But that was an improper posting. And so I apologize for the inconvenience and thank you all for rescheduling. We are holding this meeting as a hybrid meeting, although this time the board members are all participating remotely due to the rise in COVID, but the Kalanimoku building is open for public testimony should anyone want to provide testimony in person. And I will take roll call now with the board members who are here. And if you are participating remotely, just say your name, please, and confirm if there is or isn't anyone else in the room with you. So I'll start. Suzanne Case, chair, and I'm actually in my office adjacent to the boardroom, and there's no one in my room here, although there are people in the boardroom. Chris Ewan.
Good morning, everybody. I'm at home and my wife will be in and out, but not having any input.
Thank you, Mr. Char.
I'm present in my office and door is closed. And so I'm
Okay.
alone.
Thank you. Member Canto.
Maui member Canto, and I'm home alone.
Thank you. And Mr. Kaivi Yoon.
Hi, Kaivi at large. No one's in the room with me.
Thank you. All right, Member Canto, if I could ask you to, first of all, let me just say, if you are participating in the meeting, we will put you from the Zoom waiting room into the main room when your agenda item is up. Please remember to turn off your YouTube so that we don't get an echo when you're in the main meeting room, and turn off your audio and video until it's your turn to speak. Members of the public are able to watch also on YouTube. Member Canto, can I ask you to please read our standard contested case statement?
Sure. In some of the matters before the board, a person may wish to request a contested case hearing. If such a request is made before the board's decision, then the board will consider the request first before considering the merits of the item before it. A person who wants a contested case may also wait until the board decides the issue, then request the contested case after the decision. It is up to you. Any request must be made in writing within 10 days. If no request for contested case is made, the board will make a decision. The department will treat the decision as final and proceed accordingly.
Thank you very much. Okay, we have withdrawn from today's agenda E1 and J4. So we will not be hearing E1 or J4 today. So if you're here for those, you can go about your day. And then we're going to do the agenda in the following order. We're going to do the K items first, K1 and 2. And then we're going to do D1 and then D7 and then the M items. And we're doing it in that order so that we can accommodate people's schedule for folks who are wanting to testify live on those items. So we will proceed now to item K1. Michael, I don't hear you. Try again.
Okay, now you can hear
Yes.
me.
Hey, wait, let me
All right,
make sure,
Michael
let me make sure we have everyone in the room here.
Do the clarification. K2 first.
All right, we're on item K2, correct?
Sorry, no, we were doing K1.
K1, that's what I thought. All right,
Hey, wait,
starting again.
Sorry, Michael, wait. There's a couple people who have, who are here for this item, let me make sure they're in the meeting. Okay. Hang on one second.
Who's Fuji? The people aren't here.
Okay, the rest of the
K1.
people who are listed here are not in the waiting room, so let's go ahead. K1.
Okay, good morning, Chair, board members. Michael Kane, Office of Conservation and Coastal Lands. Item K1 is a petition, regards a petition for a contested case on behalf of Mr. Todd Dunphy on an enforcement action on the North Shore of Oahu. The board has not heard this case yet. We originally intended to present it in April. The landowner's representatives requested an extension for 30 days. It was granted. In the interim, we have received a written request on behalf of the landowner for a contested case. What we'd like to do this morning is have the board approve the petition and then delegate the authority to hire a hearing officer, delegate the authority to the chair to hiring a hearing officer to hear the case.
Okay, thank you, board members. All right. Let's see, so the only public testimony we're going to hear, including from the representatives of Mr. Dunphy, the only testimony is whether he's entitled to a contested case. We're not going to hear anything on the merits of this. So does anyone want to say anything other than what you've already included in your petition? Okay, hearing none, board members, do you have any questions? Okay, hearing none, is there a motion to approve K1 as submitted? Mr. Char has a motion to approve. Is there a second? Second. Any further discussion? Mr. Char?
Yes. I am in favor of the motion to have a contested hearing. I believe because of all of the notoriety involved, that this matter should be expedited. And as a board member, once the matter goes to a hearing officer, I'd like to be kept advised on the progress of the proceedings.
Okay, thank you. Any other comments? All right, if not, all those in favor of the motion say aye. Aye. Okay, I'm going to do a roll call for the first one. We have Ewan, Case, Char, Canto, and Yoon. That passes unanimously. We have 5 members today. Member Barnes and Ono are not present today. Okay, thank you very much. We move on to K2.
All right, thank you, board members. Item K2 is a request for a 120-day time extension to comply with the conditions imposed by the board on enforcement case OA-20-38 regarding unpermitted modifications to a shoreline structure. OCCL, our office, the chair's office, had originally issued an emergency permit for the subject structure around May or June in 2020. Our office found that it was not built in compliance with those permit conditions and presented an enforcement case to the board in August 2021. The board concurred with OCCL findings that the structure was not in compliance in order that it be brought into compliance with the original permit. The board set a deadline where October 2021, plans would be submitted to bring the structure into compliance. And by June 2022, the unauthorized structure would be removed and the permitted structure put in place. The board allowed the new structure to stay on the land through August 2024. In that time period, OCCL has received, and then should the landowner comply with those conditions, some of the fees would have been waived, would have been credited against the costs of removing the unpermitted items and installing the new structure. Within that time period, OCCL had reviewed 2 plans that we found were not in compliance with the board decision. In April of this year, we did receive plans that we feel are in compliance. Pending the outcome of this board meeting, we would forward those plans to the chair for review and approval. June 2022 was the deadline for removal. The landowners have asked for a 120-day extension on that. That extension would also extend the time period where they can credit the costs against the fine. So that would bring it to June, July, August 2022 would be their new deadline to remove the structures. Our office is willing to consider this request and will recommend that the board approve it. Thank you.
Thank you. Okay, questions, board members? All right, does the applicant want to make any comments? Mr. Overton?
Good morning, Chair and members. Jeff Overton with G70. I'm also joined, I believe, in the boardroom, Marie Kramer, representing the owners, Douglas Johnson and Marie Kramer. Ms. Kramer may wish to offer her own testimony. Thank you very much for hearing this time extension. We really appreciate OCCL's efforts to work closely with us to work through this challenging situation for the owners. As you had heard Michael walk through kind of the timeline of things, in the recommendation, it actually said the amendment would go till October 1st of 2022 for this deadline that we're facing. So I'd like to clarify that date as one point. The other being, the owners are going to great expense to prepare what is a temporary erosion control structure for emergency protection. We really appreciate offering that. If we could, we'd like to have a 3-year lifespan to this structure as it has been in the past for emergency protection structures. And we had sent a letter in after our original request for testimony. Other than that, I think Michael covered the points. The challenge for us as agents for the landowner and the owners themselves, there's a sequential series of approvals. So once we obtain the emergency protection approval, we then work with Cal and the Land Division to obtain the revocable permit. And we could not apply for that without first having this new emergency permit, the new design of the structure approved. So you can see the dilemma we're facing. Plus, when we talk with Cal, the workload he has, as do the staffers, Trevor and Michael, everybody's loaded up with work. And so what's happened is, even if we filed today, we're told it's possibly 2 months before they could even begin reviewing a revocable permit request. So we're stuck in this kind of tough regulatory timeline. And that's why we're pleading for this extension. If we could, please go through this process with the date being October 1st per the letter that was issued last week. Thank you.
You look into the
Member
camera.
Canto.
So I have a couple of questions for you, sir. So I'm looking at August and then October. Not quite sure which day we're supposed to consider. Are we looking at October? And then if you could elaborate on the emergency permit that you're looking towards getting, how does this work?
Okay, so it is one and the same. It's the same approval for this temporary sandbag structure. As Michael had said, the structure that was built under the prior emergency protection was deemed excessive, right? And that's why we came before the board in August last year to discuss that, how they would pull out what is still out in front of the property now. They would remove that, build a new one that complies with a plan. The difficulty we had is the contractor actually worked on a plan right after that August meeting, and it was still not the right design. So that got rejected by OCCL. So here we are now, finally at a point where, the plan is appropriate. Staff has offered its blessing on that. And now we're preparing to go forward, but that's the first approval is yes, the emergency permit can be approved for the new sandbag structure and the removal. Okay. The second permit that we need is encumbering on land that's in the state jurisdiction, right? And so Cal Miahara on the land division is the one who helps process a revocable permit. I think we have to come back to the board to finalize the revocable permit, if I'm not correct. So there's another step till we can actually build the new structure. And that timeline, I've been working with Cal since back in February, trying to get going on the revocable permit. He said, I cannot review anything until we finish what we're hoping to accomplish today, is approval of the emergency protection permit, amendment of the design, and also pulling the old one out. I hope that's clear, kind of a long litany of steps.
And you would be comfortable with the October 1 date? Is that what you're saying?
Well, August would probably not work because I have no idea how fast land division is going to be able to approve the revocable permit. We're good with the design. We're ready to remove. We want to do it during summer because that windward North Shore coast is really exposed starting the north swell season in September, October. So we'd like to get done by October 1st at the latest.
Thank you. Thank you, Chair.
Michael, to come back and just clarify this exactly what the approval is today and what the timeline.
Another chair. Another chair.
Yeah, we can.
I need the chair.
Thank you, Chair. We're actually only recommending one item. So on the original board decision, which is attached as Exhibit 1, we're looking at condition number 7, and that mandated that the reconstruction of the emergency temporary erosion control structure be completed by June 1st, 2022. If not, fines would begin to accrue on a daily basis. We are recommending, per the landowner's request, that be extended to October 1st, 2022. with the understanding that daily fines would also not start accruing. So we are only looking at condition number 7 of the board decision. And
Okay. So this is only a postponement to October 1. It's only a time extension today of 3 months, 120 days. To
Sorry, can you
October.
repeat that, please?
Just a
sorry,
second.
Chair, we do have Ms. Kramer at the desk
Yeah,
also.
I know. I just want to make sure everybody is clear on what the recommendation is.
Yeah,
Okay,
thank you, Chair. So Michael, it's Kavy. Michael, all other conditions, all other 11 conditions still apply, correct?
That is correct.
Okay, thank you.
okay. All right, Ms. Kramer, do you want to make some comments?
No, Michael just said what I was going to say.
Okay,
So I just,
right. Is there, Mr. Overton?
Okay, thank you, Chair. So just wanted to follow up on what was a letter that we issued over the weekend that requested that we would go to a 3-year lifespan starting October 1st for the structure, which is a extra request. It was not in our original submittal. And we just ask that the board please entertain that, similar to what the prior emergency permits have granted a 3-year lifespan. Thank you.
Okay, so I guess I want to acknowledge it, but that's not what's on the agenda today, so we are not able to consider that today. So I'm sure OCCL will review it and will determine what to do
Thank you.
on that. Chris Ewan?
No, I was just about to say that if that request was out of order today,
Yeah.
it could be looked at later, just as you just did.
Okay. Is there anyone else in the boardroom wishing to testify on this?
hey, tell her no. No.
Okay, board members, any other questions?
Just to be sure, so Chair, the fines would start October 1
Yes.
if this were, okay.
Mr. Overton?
I keep asking questions. I'm sorry. So things that are out of our hands, if we have a permit today, that would be great. We'll file immediately with Cal at the land division. And we really hope we can expedite the revocable permit in time. We can keep the staff updated on its progress. And we're hopeful we'll have the revocable permit in hand so that we can do the work and be completed for October 1st.
Okay. All right, any further questions? Mr. Ewan?
I'm wondering if, in the light of this uncertainty about when we're going to be able to act on the department side, we could say that the fines, that the chair has the discretion to postpone the onset of the fines if it's due to circumstances out of the control of the applicant. Do you object to? Did you see a problem with that? I mean, I trust the chair and the staff that if there are really good reasons to delay it for some, not open-ended, but for some period of time, say 3 months after October 1, through no fault of the applicant, that that they haven't been able to get the permits in place.
Yeah, so, Chris, I hear you, but, the original kernel of this is a violation,
True.
right? And I think, this 120 days is being lenient, and I'm concerned about if they're willing to do it in that time, but I won't entertain, not fining, because again, this is a violation, period.
Okay, I mean, if you object, I'm not going to suggest that as an amendment. The department can, if they see if they feel it's appropriate, they can bring another matter to the board like this, before October 1. Okay, thank you.
Okay, anything else? If not, I think I'd like to entertain a motion to approve K2 as submitted.
So moved.
All right, second. Thank you. All in favor, say aye.
Aye.
Aye. Okay,
Aye.
thank you. That passes unanimously with 5.
Thank you very much.
All right, thank you.
All right, thank you, board members.
Okay, we're going to move to D1 next.
Yeah, you can come on. The,
Okay, let me hear
Hello,
first.
everybody.
Land division.
the administrator is gonna give the, you first, you have to wait. I don't know who the signing person is. Where's Russell?
Arlene, there's a couple of people in the waiting room that I can't identify, so. Okay, Russell, D1, please. Sorry, yeah, D1.
Okay, D1, board members, we're bringing back to the board for an amendment for an item on Kauai that was previously allowed to be extended. It was a lease about to expire, and we're coming back to make some changes to some deadlines that was imposed. One in particular was the closure of a cesspool, a large capacity cesspool, to bring it 1 month earlier and to be consistent with a subsequent EPA consent agreement entered into by the department that requires closure by June 30, 2022. And so we're basically asking the change to be changed from July 25, 2022 to June 30. We're also asking the board to bring back to approve a special installment agreement for the fine that the state has already paid to the EPA attributable to this particular parcel. As far as the long-term solution of the cesspool, the lessee has evaluated many different scenarios. Initially was looking at a septic system, then later was seriously evaluating the ability to connect up to the county sewer system. However, the cost estimates on those exceeded the budget for this lessee. And so he's currently, my understanding is back at evaluating a septic system or individual wastewater system on site. He's made some improvements to the property, roughly 20-something thousand for a new roof and some facial improvements that will be included. But we're asking this board to approve the prior approval, which was to extend this particular lease, which was set to expire in 2019. I don't have anything further. I'm available for questions. My staff person, Allison Newston, is also available if need be. And I believe the lessee is present.
Okay, questions, board members of Land Division, Mr. Char.
I was interested in looking at the map. It looks like a fairly, there
Hello,
are a
this
lot
is
of
Darlene.
lots in the vicinity.
I see you in
And
my
I'm sorry.
waiting room. I don't know who you are. It's
Darlene,
on the phone number. Oh,
Darlene, we can hear it. Darlene,
okay. Okay, perfect. Okay. Oh, do you want me to resend it? If you email me, I'll resend you the link. Again?
Darlene,
Okay.
Darlene, we can hear you
Hold
when
on.
you,
I'm sorry.
okay, sorry,
No, can you send it again? What's the name under?
just a minute.
Listen. Okay, bye.
Pretty hard to run a hybrid meeting.
Good job.
Okay, Darlene, just so you know, we can hear you on the Polycom when you're on the phone there, but thank you for checking on that person in the waiting room. Okay, Mr. Char.
Okay. Russell, looking at the map, it looks like it's a fairly dense populated area. And I'm wondering whether the other lots are having similar problems on setting up a system for waste. That's one point. And the second point is trying to get some idea of what an aerobic individual waste system is, as distinguished from a septic tank.
Well, on the first question, Berman Nachar, maybe my branch manager on Kauai can answer that. I assume as far as other lessees, this is the only lessee I'm aware of that has this issue.
Yeah, I'm not aware of other people in the area, as we don't have other tenants with these type of systems in the area. We only have an empty parking storage lot.
I'm looking at Exhibit A. It looks like it's a fairly populated area.
It is. I mean, anyone else in the area is going to be faced with the same situation. They either would need to attach to the county's sewer line, which would incur the same costs that this tenant would be incurring, or they would be forced with, I mean, the residential places in the area, I assume, are either on cesspool or septic tank, and I really can't speak to the water levels for the neighboring properties.
Can you tell me a little bit about what this so-called
Aerobic.
what is it? An aerobic individual water system is?
The lessee is on, maybe he can explain it a little better.
Hey, everybody. The anaerobic system is basically just a
Sorry,
way to
can you please state your name for the record?
Sorry. My name is Aaron Feinberg. I'm the leasee for this property.
Thank you.
The anaerobic system is basically a way to treat the waste because of the groundwater level to the property. We recently had, in doing all of these processes, a test done that resulted, even with tidal differences, roughly 3.5 feet below the concrete is the water table, which is extremely problematic. Also, the reasons why even why the two septic or the two non-septic systems that were considered were quite expensive. The reason that this area in particular is difficult to deal with, other than the water level issue, is that the county sewer system is not expanded throughout Kapa'a. So right now, the closest manhole cover is over 200 feet down the road. All the other people in the area deal with the same things. As we all know, Hawaii has cesspools all over the place. From what I understand, and I'm going to keep tangenting a little bit, I was told by multiple sources that the county of Kauai has a $40 million plan to improve the sewer pump that's going to therefore expand this county sewer system throughout Kapa'a, and thus I would be able to connect in a future date to the sewer system. I know myself and other properties have dealt with the same thing at great expense. My concern is just, one, the closure, which will be done, and then two, coming up with a solution that I can maintain my tenants and myself as residents to the property.
Thank you.
Other questions, board members?
Mr. Fine, what kind of, sorry,
Go ahead.
Mr. Fine, what kind of business is A Fine Holdings LLC?
A Fine Holdings is just my LLC to manage this property. I have another business that has been my main source of income for 10, 12 years, which has been struggling over the pandemic, as much things are. Yeah.
Okay, thank you.
Okay, any other questions? Did you want to add something, Mr. Fine?
Yes, please. So the board submittal, to give you guys, I don't know how familiar you are all with this case. I started with Kauai Eco Design in the summer of 2020, after it was brought to my attention that the
property was in violation. When I took over the lease from the previous owners, which were in default, none of this was told to me by either board, the current, my contact at the time was Kurt Yasutaki, who was basically seeming like learning on the fly for the entire time. So when the EPA levied the fine, it came on to me without my knowledge that I was in default. The fine that was levied, I was going to be bulking into a mortgage situation to be able to pay for this and then recover the monies over time. I understand that the fine was delayed for being payment. Once that was brought to my attention, I, in good faith, made a large payment, and then we were entering into an agreement to maintain and make sure that it gets paid. The initial plan was to come up with a force main solution. Quiet Eco Design was brought on to do that. The plans basically are wet and signed and stamped. And at that point, I was told that Russell didn't like the system. It was like, it didn't sound good. They didn't want anything to do with it. This is after spending $40,000+ and ready to go and mobilize and get bids. Since the delay between pausing on that and then getting more bids now, gone through a pandemic and everything is doubled in price. So something that I have a tentative bid for $223,000 at the end of 2020 is now $450,000. And they're unreasonable to recoup that monies in the time. So now I'm scrambling, and this AIWS system, which was brought up to my attention, we look like I'm heading to the DOH afterwards with my variance submittal because of the level of the groundwater. I have to submit a variance, which the DOH and the DOW, basically everyone has been involved in this process because I've been working with Quiet Eco. So we're going to be submitting for the variance, which hopefully we'll be able to get through, and then we will be able to at least utilize the property. Right now, we've been using porta potties and portable sinks for quite a while. The one major note that I'm asking for an amendment is that right now it states that I have until July 25th to install this AIWS system, which is unreasonable. I'm going to need, I would say 6 months would probably be fine, but for safety, I would ask for more. Additionally, I want to add that I've had multiple conversations with the EPA over the last couple years. Most recently, first in March of this year, Jelani Shareem from the San Francisco office called me personally to ask how the cesspool closure was going. And at that point, he made it very clear that the EPA was offering extensions just purely by asking. And I pressed him on this because that would be great. Like, there's no reason that we have to rush to close this in June 30th, because now it's going to be closed. I'm not going to have an IWS in place. And he said all we have to do is just write an email to them from the DNLR saying, hey, this is what's going on. We would like an extension. And I brought this to Allison, who brought this to Russell. And again, this was shot down as unreasonable. For what reason, I don't understand necessarily. It's just an email to the EPA saying we would like an extension. I called him up 2 weeks ago to say, hey, what do you need? And he reiterated, like, I told him about the 5-year plan for the county to extend the sewer system, because obviously I would prefer, and I'm sure you all would prefer, that we connect to sewer. I'm not necessarily asking for a 5-year extension. I think we can do this IWS and make it work. And then when the county does band out, hopefully it is less unreasonable in cost. But the EPA offering the extension to me without me going to them was really nice, and I thought a great way for us not to bump into unnecessary deadlines. That being said, just to reiterate, we just need to move the July 25th deadline to install the IWS. I'm going to request a year, but I'm okay if the board decides a little bit shorter.
Canto?
I have a question for Russell.
Yes.
Russell, could you elaborate on his comments about why,
On the closure.
Your closure?
Well, number one, closure is not the IWS. Closure is the filling of the cesspool with concrete and doing it with it as permitted by Department of Health. From what I understand, we've been told that they've stopped using the cesspool, but it has not been closed. So part of the process requires official closure. Secondly, and so that was what we're asking the board to amend to make it consistent with the consent agreement that was entered into with the EPA. As far as us asking the EPA for an extension on this, I did not favor asking an extension on this particular matter. We have other matters larger that we're currently negotiating with the EPA on a larger statewide audit I may need concessions from the EPA or more flexibility. I think the closure right now, being that the cesspool they've stopped using it, all that is needed right now is $30,000 worth of concrete to fill the hole and get it permitted for closure, official closing. As far as the actual installation of a alternative approved septic system, we've asked for a July 25th, 2022, which is originally the lessee's proposed date. But I think as long as the lessee has if tenants are on the site, I think he needs to work closely with Department of Health on whatever temporary systems he has there at the site, which would have to be permitted and authorized by Department of Health. I do not necessarily object to him doing that until the actual installation, but keep in mind, his lease expired in 2019. This whole extension was based on improvements made to the site. And to this day, I think roughly less than 30,000 have been spent on the improvements.
Okay, Chair, can I ask the lessee a quick question?
Yeah.
So, sir, you're having heard Russell Suji, Mr. Suji. Can you comment on any of this? I mean, are you aware of everything that he had mentioned a minute ago?
Oh, I mean, I think the gross expenditures are greatly understated. I mean, I've spent over $44,000 with Kauai Eco Design, and that's not a physical thing that's been done to the property, but that's a tremendous amount of money that's been invested into something that I'm trying to do the improvement to the property. There's been over $5,000 of portable toilets that's been purchased in the lieu of this fine. We had a termite infestation that we had to take care of over $5,000. I've gone through and paid all the back taxes and back rents that were owed when I took over the property from the previous lessees. And I still owe for my personal loans to make this thing happen. This is a long-term project for me. So the main expense for this extension that was granted was going to be the conversion of these cesspools, and that is still the case. However, it's obviously taken quite a while with a bunch of starts and stops to make this happen. The force main, which was proposed and drawn up and wet stamped by the county, was the main thing that this was all based on. So now having to pivot and put more money into engineers and then again the property. The reason for the extension, right now I have Cushnie Enterprises. They're going to be closing the cesspools in about 10 days. That's already on the docket. They'll be closed by the deadline. The reason for the extension that I'm asking, one, for the installation of the IWS, it would be nice. It's not necessary because if I have to do it, I will. But if I can close them and put in the IWS at the same time, that's going to help everything out, because otherwise I have to rip up the concrete twice. Everything has to be done twice, basically. So if we move, again, I understand you have a lot going on. A simple email to Jelani, who's is aware of my project, and we can do everything together, that would help out greatly. If the board decides that we want to close it immediately, that's okay. I just need more time to install the IWS.
Okay, thank you, Chair.
Does that answer your question?
Yeah, thank you.
You're welcome.
So let me just clarify where we are, again. So I know you wanted to propose a force main. I know there were issues with that because, we had some internal conversations on it quite a while ago. I appreciate that you made all of those other expenditures. I think they sound to me like, repair and maintenance expenditures that are not counted in the equation, for the improvements for the extension. But I recognize that, number one, that you've made a lot of expenditures, for the property, and also, obviously, the cesspool issue is a complicated one, and we have been working with the EPA, and, a lot of us are, in the middle of this process to do these conversions that the EPA is, enforcing, rightly so, because they are, as you said, with the high water table, they're polluting the water. So it is important work to be done. So maybe could you elaborate on, so what you're saying is that if you go ahead and close it, which you can do quickly, and we would not have to ask for an extension from the EPA, you can do it quickly. But you said in order to, if you had to do that separate from installation of the wastewater, the new wastewater system, you'd have to dig up the concrete again? Why is that?
Well, to install the proposed septic system, the parking lot will have to be dug up so they can install the septic tanks. So they're going to have to dig up the parking lot to get to and close the cesspools, and then in theory close it up, and then open up everything again in a few months when we get the IWS finally on board.
So is that going to be in the same location?
Yeah, I mean, there is a space issue, but we already have a design from I think it's Summa Engineering. I'm sorry, I can get the exact date. Allison is familiar with the engineering firm. She's been CC'd on them and knows the process that we're going through. So we already have a bid. I have the variance request that I showed a minute ago. I'm actually, after this meeting, going to go up to the wastewater division and pay them the variance fee in person. So yeah, so basically, optimally, we do everything at once. Obviously, there's deadlines that were imposed by the EPA that need to be met. So if we have to dig up twice, so be it. It's just not optimal. That's all. Yeah. I appreciate the understanding and asking for the extension.
If you might clarify one point, we on this, the systems that the lessee looked at, if I just want to clarify that initially we were told he was looking at a gravity fed system, i.e. right into the county sewer system, which would have been the ideal. After spending money with his engineers, he decided the cost was prohibitive. He then started looking at a force main system, which would have required a pumping and a lessee continuum maintenance, and ultimately the state taking over the property and maintenance responsibilities, ultimately if the lessee was no longer around. That was option 2. He studied that and was pursuing that. And the department actually wrote a letter saying, reluctantly, we would agree to recommend that to the board. We were subsequently told it was cost prohibitive by the lessee. And so now we're being told he's looking at a septic system. And that's where we're at today. And, I'm not exactly sure. I know the submittal, as you read it, is a little non-committal on the type of system, because it says that the current cost of the septic system as estimated by the lessee was $300,000 and it was cost prohibitive. He then indicated that he would spend at least $250,000. He must spend at least $250,000. And so on page 6 of our submittal is the breakdown of the $250,000 estimated cost, with language to indicate that the lessee may need to alter that to wastewater system that is ultimately permitted by Department of Health that meets his budgetary balance, basically his budget. Thank you.
Mr. Ewan?
I'd like to make one comment. His problem is our problem. Without him fixing the septic or sewer issue on the property, we have no viable tenancy.
That's correct.
So we have somebody who's working on a problem to fix it, that he's encountering these issues, and the issues are there. I mean, I don't think he's creating the issues. And someday we want this, we want the sewer issue fixed, and better in the context of having a tenant who's working and trying to do it. So I'm for reasonable accommodation of the tenant. It sounds to me like he's working hard on it, and sooner or later, either somebody fixes this or we have an unusable piece of property. Maybe we could have it as a parking lot or something that doesn't require a sewage treatment solution. But for the viability of lease that and usefulness of the property, we do want to get this fixed. And if it takes more time to do it, I don't see how that hurts us.
Yeah, I totally agree, Chris. I was going to comment on that very point. Having a longer view, however, with the water table 3 feet below top of finished concrete, I mean, and with sea level rise, I mean, I'm not sure. I mean, we're just band-aiding a problem here, but I agree with you that his problem is our problem.
Mr. Fine?
Yeah, thank you too for understanding. Just to clarify, the initial plan, and I believe you have that in one of your exhibits through Kauai Eco Design, was actually the force main. That from the first evaluation of the property, they went through and studied what would be possible, and their recommendation and movement forward was the force main, nothing else. The gravity fed is just because of the water level. It would be extraordinarily, I think it was like $600,000 is what the estimate came in to do the project. And then so force main, which I'm learning about this too as we go along, I'm honest with that. The pump that's used is extraordinarily reliable. And I understand that there's accommodations that you all need, but it's a good system. It's a really solid system. These people would not use it if it wasn't the case. And on a long term, yes, I understand this is putting in a septic is a Band-Aid type situation, assuming the county does go through, and they will expand their wastewater treatment plant. They're saying 5 years. Is it 5 years? I understand that also might push, but expanding the sewer system throughout Kapa'a, being that the manhole is only a couple hundred feet down the road, that will definitely come up and serve all the other businesses in the area. And additionally, in the comments to making it a parking lot, I know that doesn't give you guys any revenue, and there's 6 to 9 different businesses that will be kicked out. I know you have testimony from a handful of them. One of them is myself. I use it as a warehouse, super simple, but we have healthcare providers, we have a tattoo shop, we have multiple other people that rely on this property and would have very difficult time finding more space.
Mr. Char?
Yes, I guess back to Russell again, trying to get a general context of this situation. My understanding is that this is under a lease extension of 15 years from 2019, so it's only got 10 plus years to run. And
Yes.
secondly, that being the case, who owns the buildings at this point? Because this was acquired near the end of the original term. Are the buildings owned by the tenant, Or is it owned by the state at this point? And then-
Owned by the tenant during the tenancy.
Okay, so
That's
the
correct.
rent is predicated on the land itself only.
The landowner.
And
That's
then on the
correct.
surrender, at the end of the 10 or 12 years more, what happens? Is there any surrender provisions to either restore the property back to, vacant, or do we have an
Yes.
Uncle Billy's problem?
Again, unless we're allowed to add those provisions in during the extension document. Unfortunately, in this case, this lease was issued very similarly like Uncle Billy's, and it has a provision that says that the property would then revert to the state. So yes, I looked at that this morning specifically, hoping that it would have a removal of those improvements so that, once the cesspool is closed with concrete, that we would not have to deal with a structure that is on the site at the end of the term. Unfortunately, this lease, unless the AGs allow us to bring the provisions up to the most current standard form during an extension period, which I don't think they will agree, it looks like we'll be having to deal with the building at the end of the term. The alternative, that's also always is out there is the problem that we'll be left with the site with buildings. May not have tenants, but it'll be site, it will stop the EPA and the fines that could be assessed against the state for violating the consent agreement. But the problem is we still have the structure there.
Russell, is there any issue with us granting the extension requested on the condition that EPA approve it?
On the filling the hole with the concrete?
Yeah, I mean, it does seem like extra work to have to fill a hole and then dig it up to install the new system. So can we grant a 1-year extension provided that the EPA approves it? He's made representations that EPA has said it's not going to be an issue to do it. He's obviously working on it. So can we do it that way?
The board could, yes. I was hesitant on doing that myself
Yeah.
because we are working on a larger consent agreement.
Yeah, understood. And I think these are, complicated but separate agreements. So if it's not an issue for the EPA on this one-off, then I think we can go ahead and do it. The board can do it. I understand your reservations.
I'm assuming also that this so-called Roby individual waste system is approved by the EPA. Is
And the
that
Department
correct?
of Health. Mr. Fine, is that right?
Yes, that's right.
I mean, it's not
It
like,
has been approved or it will be, you expect it to be approved?
okay.
Pardon me?
Both at this point. Both at this point. The EPA, in my conversations with Jelani, said as long as the DOH and DOW and everyone in the local government approves the system, the EPA has no problem with it.
Okay, are we ready to make a motion here? Any further questions?
So Chair, I'm sorry. So based on that conversation, are we tweaking the recommendation or?
We can entertain a motion to modify this board submittal.
Yes, I'll make a motion to approve the board submittal with an amendment to number 2 that extends the deadline for closing the cesspools to any date allowed by the EPA, making it a requirement that the cesspools remain abandoned and not in use, and also extending the time to install the wastewater, to install the new wastewater system, and I'm not sure of the date that we should put for that. Maybe a year?
So what if we put a maximum of a year for both of your items? Because if they're going to be done at the same time, we don't want this to float out into the
Okay.
future, undetermined future, so.
So both deadlines would be a year, and the cesspool closure would be subject to, of course, the EPA approving the extension of its deadline.
Yeah, okay. We're good with that?
Can I get clarification, please?
Yeah.
Okay, with this extension, just to keep in mind, the extension document has yet to be executed because of all the changes. So I think we're going to have to proceed with executing an extension document. I would suggest, and I suggest that this board consider that if any of these deadlines are not met, that ipso facto, we revert back and the extension would be considered as non-existent, and we revert back to the current situation. Because otherwise we'd have a situation where we have a lease, the deadline for conversion will be into the extension document, but those improvements was never completed. And otherwise the lease would have expired in 2019. Is that the board's understanding, or are we going to be in just a lease default situation with a lease extension going forward in the future? If I may.
Ms. Panto?
So in answer to Mr. Suji, so would fees apply if they default on the new recommendation?
What was that again?
Would there be applicable fees assessed to the client, the lessee, if they don't meet the 1 year?
We don't have fees in here for that. It would be more, your extension is not valid, is what I think we were, because these are the promises that was made to get your extension from 2019 going forward. And now we're looking at an indefinite period of when actually these improvements, at least for another year, will be made, or until 2023. So if in fact he misses that deadline, my question really was to the board, do we revert back to as if no extension was ever granted, or are we looking at a lease default situation we'd have to take back?
I think
to the next board?
it would be a granting of the extension, but subject to default if the improvements aren't made.
Yeah, I wouldn't want it to say that it's an automatic default. If it's not, the time is not met, the land division can bring a default back to the board to consider, like it can in any other situation when conditions are not met. And whether it would be defaulted is another question. The law basically does disfavor lease defaults.
Okay, so Chris, can I ask you to just reiterate your motion with these clarifications?
Yeah, the motion would be to amend number 2 of the recommendations to extend time to close the cesspool and install the new wastewater system for a maximum of a year, let's say July 25th, 2022, unless EPA does not consent to extend its deadline. And that would be it. And I think that the matter that was of what happens if they don't is the division can deal with it at that time, rather than us say that's voids the lease extension. Mr. Fine wants to say something, and I'm not. In a situation like this, I would like to hear.
Go ahead, Mr. Fine.
Even though he's not, even though we're in deliberations, we normally wouldn't be taking a discussion at this point.
Yeah, Mr. Fine, go ahead.
I just wanted a clarification. Just the 1 year extension best case scenario is to do the cesspool and the IWS. If the EPA doesn't, for some reason, after multiple times indicating that they would, then the cesspools would still be closed by the June 30th deadline. I just need more time to install the IWS. So either way, like the IWS can be a year, but I would prefer to do both the cesspool and the IWS within that year.
That would be correct.
Thank you.
Okay, any other questions? Okay, if not, is there a second to that motion?
I'll
All
second.
right, all in favor, say aye.
Aye.
Aye. Okay, any opposed? Okay, that passes unanimously with five. Thank you, Mr. Fine. Appreciate all your efforts on this.
Thank you all. Appreciate it very much.
Right. Okay, we are going to go to D7 now.
Okay, D7. board
Wait, hang on,
members.
hang on. I gotta get Mr. Murray in the room here.
Are you D7?
Yeah, let me see if he's here. Mr. Murray, are you here?
Oh, yeah.
Sorry, is he in the boardroom?
Oh,
Hi, I'm here. Sorry about that.
Okay, right.
Sorry about that. I'm here.
Yeah, let me see if he's here. Mr. Murray, are you here?
Yes, I am.
Okay, can you turn off
Yes,
your YouTube because we have a repeat?
Okay, yeah, 1 second. Let me
Sorry,
get,
is he in the,
can you hear me?
I think that's good.
Hello? Okay, sorry about that.
Okay, thank you. All right, we're gonna hear from Land Division and then you can make any comments you want. Okay, Russell, D7, please.
D7 is a request for a right of entry from Waikiki Beach Activities over a portion of Du'Kanamoku Beach. Apparently there is they're having a corporate event on site. The request is pretty standard. We have a standard request. I don't have anything further to add unless this board has any questions. Thank you.
Any questions, board members? Mr. Murray, do you want to add anything?
No, just thank you for your consideration. You know, the group market around the state, like these corporations and so forth, are starting to come back. So, you know, they're just looking at all the different attributes that we offer. In this case, it's the, you know, the Hilton Dukes Lagoon that they're going to be kind of utilizing a little footprint there. So, you know, just thank you for consideration.
Okay, questions, any questions, Ms. Canto?
Unless there are no further questions, I'd like to move to approve.
Okay, thank you. Second? Second for the Char. Any further questions? Not all in favor, say aye.
Aye.
Okay, that passes unanimously with 5. Thank you, Mr. Murray. Have a good day.
Thank you, board.
Thank
Thank
you.
you so much.
Okay, we're going to go to the M items, and then after that, I understand we have Mr. Bouchard in the rooms. After that, we will go to certain D items. So M items next. Okay, Ms. LaRue, are you here? Good morning. Okay, we have public testimony on M5. So on items M1 through 4 and 6 through 11. Board members, are there any questions? Other than M5?
Move approval, staff recommendation.
All right, is there a second?
Second,
All in favor, say aye.
Aye.
Aye, that passes with 5. Okay, thank you. Okay, Ms. LaRue, do you want to say anything about M5? Otherwise, we'll just go to public testimony. And you're on mute. There you go. Wait, I can't hear you.
Can you hear me now?
Yeah,
Okay, thank you. The only thing I wanted to say to the board was that state is not providing No Victor helicopters with additional space for the operation of helicopter tours. This submittal or this request to you is for a T hangar for the storage and maintenance of their helicopters only. So no tour operations will be happening from this area. This is simply a T hangar for storage and maintenance of helicopters. She has already been provided years ago with an operational area for three operational areas for helicopter tours. We haven't given them any more than that, and we have no more room in Honolulu to provide any more than that. So
so
this,
this would not add to helicopter tours on Oahu.
no.
Okay, thank you for that clarification. Okay, Ms. Corey Harden was here. Let's see what happened to her.
Oh,
Oh, here. Sorry, Ms. Harden, are you here? And you're on mute if you are able to hear us. Corey Harden. We cannot see you or hear you. Corey Harden, can you hear us? I can't see you or hear you.
Sarah, she's trying to reconnect.
Okay, let's go, let's just hold on M5 and we'll go to M12 through 15. Board members, are there any questions on M12, 13, 14, or 15?
Could I just, this is Jennifer Tomita, DOT Harbors. I was
Yeah.
wondering if I could make a amendment to item M14.
Okay, go ahead.
So for area number 6, instead of the security deposit that is listed, Harbors would like to request a surety bond in the amount of $150,000 to ensure the pier can be restored to its original state.
Okay. Board council, I assume there's no issue with that from a notice perspective. I think it's okay.
No, it looks okay to me.
Okay. Board members, any questions? Okay, if not, is there a motion to approve M12, 13, 14, and 15 with that one amendment on M14 to request for area 6, rather than a security deposit, a surety bond in the amount of 100, did you say 150,000?
Yes.
Yeah. Is there a motion to that effect?
So moved.
All right, is there a second?
second,
Thank you. All right. All in favor, say aye. That passes unanimously with 5.
Thank you.
Thank you, Harbors. Have a good weekend. All right, Ms.
Not
Harden.
yet, Chair, not yet. It's Tuesday.
Yeah.
have a good week.
All right, Corey Harden is back in by phone. Let me just make sure she's able to hear. Wishful thinking on my part, huh?
Mhm.
Especially after a 3-day weekend. I don't know. All right, Corey Harden, can you hear us now? And you are on mute on both your phone and your computer.
Unmute. Oh,
Oh, there you go. We can hear you.
okay. So can you folks hear me?
Yes, and I wanted to make sure.
I can't hear you.
You cannot hear us.
I'm gonna phone back in. Perhaps you want to do another item while you're waiting. So, sorry.
Okay. You know what? Let's just take a 5-minute break.
Sounds good.
Yeah. So, but this one is, yeah, so you can call in now.
Russ is Ronan Char. I
Okay, we can start up again if everyone is ready. Okay, Miss Harden, can you hear now? And we can hear you. Actually, you're on mute, so.
Hello?
Yes, we can hear you. Can you hear us?
Oh, very, very good. Thank you for your patience.
Okay, no
so
problem. I wanted to make sure you heard Ms. LaRue. I wasn't sure if you were connected or not, but she did clarify that this submittal is to store helicopters that are already permitted. It's not to add any new tour helicopters at the airport. Anyway,
Yeah, well-
just wanted to make sure you heard that, but please proceed.
Oh, okay. Yeah, first, thank you, board members, for your service on the board. And even if they're just storing the current helicopters, the environmental impact statement for the airport is very old, and when it was written, there weren't near as many tours as there are now, and not the safety concerns and the noise concerns. I mean, there's more people under the helicopters now. You know, when you folks approve facilities for the helicopters, that enables flights, that some of which are not real safe. I sent written testimony about the crash into the Kailua neighborhood 3 years ago, and the year before that, there were 2 crashes. One injured 3 people, and another didn't injure anybody, fortunately. So, you know, if Hawaiian Airlines had 3 crash landings in 2 years, would you still go ahead and approve facilities for them? And I've also sent you the testimony from 16 different neighborhood boards with concerns about safety and noise. And I'm really glad to see that Suzanne Case has been communicating with FAA about the noise regulation. FAA did write to Ms. Case, and they said the Hawaii Air and Tour Noise and Safety Task Force is addressing noise and safety issues. I went to several of their online meetings. I don't see that anything is happening with that task force. The only members of the task force from the community are 2 state legislators. There's no one from the general public, no one from community groups. The members are from industry. It's the Hawaii Helicopter Association, Helicopter Association International, General Aviation Council of Hawaii, Aircraft Owners and Pilots Association, and Tour Operators Program of Safety. So there's a rather small number of people profiting from air tours compared to the thousands of people subjected to danger and this noise that just keeps on going. So I hope you will continue to and succeed in finding a way for BLNR to take some action. So thank you.
Thank you for that, Ms. Harden. And I did post my most recent communication from FAA online. It's on the DLNR website, the board website. Just because this is an ongoing topic and we want to be transparent about it. I find it very frustrating that you know, obviously the Hawaii DOT says they can't manage aircraft noise and safety issues, that is an FAA thing, and the FAA says they can't do it either, but that we can't do it. They say basically that they only manage safety issues with regard to basically the tour paths around the airport, and that's what they do, but nobody else can do anything. So it's a frustrating situation, and maybe it's a federal law situation, but it is frustrating for people who have issues with both safety and noise on the areas that helicopters are flying over. Okay, board members, other questions or comments? All right, there's no further testimony. Does somebody want to make a motion to approve M5 as submitted? Okay, let's see, Mr. Char moves approval, and Ms. Canto, you want to second that? Okay, then, all in favor, say aye.
Aye.
Aye. Okay, I will note reluctantly on my part. But that passes. Okay, thank you, Ms. LaRue. Have a nice rest of your day and week. And then weekend. Okay. All right, we're going to move to item D2 now. And I'm really just trying to make sure we cover items that we have members of the public here to testify for so that they can go about their day. So we're going to do D2 and D3 next. Hang on, let's make sure we have everybody in the room. Darlene, are you there?
Yes, I am.
Okay, all right,
I'll bring them to the table.
all right. Okay, Kevin Moore, I think you can go ahead.
Okay, good morning, Chair, board members, Kevin Moore with Land Division. Item D2 requests the cancellation of the request for qualifications, request for proposals for the former Uncle Billy's Hilo Bay Hotel. The goal of the RFP was to find a developer willing to renovate the property under a new long-term lease. The board approved the publication of the RFP at its meeting of December 13, 2019 under item D3, and a copy of that board action is attached to the staff submittal as Exhibit 1. It provides additional background, and I'll just recap a few highlights here. The department's architectural consultant who studied Uncle Billy's recommended in its report of June 2016 that the hotel be demolished. Hotel operations at the property ended on June 19, 2017, after the County of Hawaii wrote to the department stating the property was unsafe and should be vacated immediately. The board then issued a revocable permit to Tower Development, Inc., covering the property for security purposes, and the county allowed a convenience store to operate there in the interim. Then after COVID hit, Tower surrendered the revocable permit around August 2020, and the store shut down shortly thereafter, leaving a completely vacant property there. In 2019, the department unsuccessfully sought a legislative appropriation for the estimated demolition costs of more than $8 million. But without any funding for the demolition, the department tried to pursue an alternative action, which was to renovate the property under an RFP. It's kind of a backup plan based on the architectural study. Okay, so that RFP was published on August 23, 2020. Only one developer, Tower Development Inc., submitted a statement of qualifications and a proposal for the property. Tower and its affiliates are the majority owner of WHR LLC, who holds the lease for the Grand Naniloa Hotel, which is next to Uncle Billy's. An evaluation committee appointed by the chairperson was set to recommend the selection of Tower to the board at its meeting of September 24, 2021, under item D5, but the matter was withdrawn from the agenda after a lawsuit was filed by one of the members of WHR, and that's Olson Naniloa LLC, alleging that Tower's submission of a proposal under the RFP was a violation of WHR's operating agreement. That complaint also questioned WHR's solvency and sought an audit of WHR's financial books and records. The evaluation committee then requested additional information from Tower regarding the allegations in the complaint, as well as information on Tower's finances and the finances of its principals, Ed Bouchard and Stuart Miller. In November 2021, Tower provided consolidated financial statements for the years 2020 and 2021. And those statements listed the Nani Loa Hotel as a major real estate equity of Tower. Mr. Bouchard declined to provide tax returns for Tower or personal financials for himself or Mr. Miller. And his explanation was that the kind of information we were asking for is not relevant to how developers operate. He said that involves identifying an asset and getting financing lined up through investors and lenders. In December 2021, the mortgagee on the Nani Loa Hotel property filed a foreclosure action on a loan of approximately $50 million. On March 4 of this year, a fire occurred at Uncle Billy's. We also received reports this weekend that 2 smaller fires occurred there on Friday and Monday. And again, even before the fires there this year, the architect's recommendation as far back as 2016 was to demolish the property. This legislative session, the department did get a CIP appropriation for demolition in the amount of 13.5 million. However, the legislature made the funding source the Special Land and Development Fund, which doesn't have 13.5 million to spend on demolition right now. The plan is to do the planning and permitting that are required for the demolition, get that started, and by the time next session comes around, ask for the source of funding to be changed to the general fund. The RFP reserved to the department the right to cancel and reject any submissions when in the best interests of the department or the state. Staff now seeks the cancellation of RFP on this grounds and the rescission of the board action of December 13, 2019 under item D3. Land Division will focus on the demolition, starting with the planning and permitting, which we, as I mentioned, can be covered from the Special Land Development Fund budget. Thank you.
Thank you. Questions, board members?
I just want to make sure that I'm absolutely clear on what we're doing here. If we approve the staff recommendation, we are giving up the idea of having a private developer renovate the site, and the state would be responsible then to demolish the building, hopefully with some funding next year, and then proceed with a vacant site to decide what to do.
That's correct.
We had another entity that was interested last time, but was untimely. Do we know anything about them?
Yeah, that was local homes. I don't have a lot of information about them, but yeah, they were untimely on their submissions and ultimately did not submit a proposal.
Okay, that's all that I have right now.
Okay, any other questions at this time? No, we have Mr. Bouchard here to testify.
Well, aloha. Thank you, Chair and board members. This is Ed Bouchard, CEO of Tower Development, who is the managing party for WHR, who owns the Nani Loa. Tower's been the manager since day one. Tower was the one who bid a bankruptcy in 2013 to purchase the Nani Loa out of bankruptcy. For many of the board members, they may not know the history. So Tower raised its hand and said, I'm going to go help Hilo when there were no windows in the Nani Loa, and many rooms were just see-through cement walls. And it was probably, in some people's view, as bad as Uncle Billy's is now. We went over, Stuart and I went over there and committed to Mayor Billy and the community of Hilo that we would do everything in our power to revitalize Hilo and bring in a Hilton brand and help Merry Monarch have a great hotel to celebrate its Merry Monarch festivals and all the things that were needed on Banyan Drive. that was out of heart. We didn't know if we'd ever make any money. That was out of Tower's desires to help the community. And here we are now with the same request of Tower to help with Uncle Billy's and Country Club. It is out of our belief that our commitment, our expertise in Hilo and redeveloping is the best party to help the DLNR do a long-term ground lease for both of those, revitalize Banyan Drive, and be a helper in the community. I have to give a little, I apologize if this is going to go on a little bit, but out of the Nani Loa, we are now doing events that have arisen out of having a great hotel. We have an employee, Noel Ross, who produced the first fashion show, out of the hotel. It could have never happened but for the nice renovations. And 2 weeks ago was elected for an Emmy to take 75 Hawaiian people to the Emmys because she has been nominated for the fashion showcase. But, you know, it started out with raising her hand in bankruptcy to allow now fashion people in the state of Hawaii to be recognized. And so it's the little things that nobody knows about all the hard work way back raising your hand on a bankruptcy that now results in the first Emmy related to fashion show for the state of Hawaii and what that's doing for the fashion industry for the state of Hawaii. So I give that little example of the same thing that can happen with Uncle Billy's and Country Club as we desire to continue benefiting the community and the people of this great state. We've been here 25 years. Our heart is to do what's right for the people. And I really would like to ask for deferral before I go into a long dissertation, because it does not seem appropriate given punting this back to the state obligation when you have a private party that's willing to work with DLNR. And I am asking for deferral for the last week of June, a meeting, because it was very difficult with Memorial Day to have the hotel commitments, our lender commitments, and everybody in the last minute switched from Friday to Monday. So here I am all alone. And it's unfortunate because we're here to help. We don't want to develop a hotel Uncle Billy's if the state just wants it to sit like it is. If they have the money and they want to spend the money, I'm fine with that. I'm here to help if the state wants to help. So I'm asking first for a deferral so that we can have Hilton here. We can have the lender who's going to do the loan to build the new hotel here present. You have private enterprise that wants to do something here. Here's our fear. If the committee doesn't personally interview us and talk to us and work as a private public partnership, the committee hasn't called me to ask me any questions on our qualifications. They just want it in paper. But this is too big for the people of Hilo and tourism not to give it time. We spent over 5 years in this process. And it just seems to me that before we punt it back to the state obligation to go spend $10 million of state money, that details of uncertainties or questions that the committee may have are given fair opportunity to be addressed. If there's a concern on where's the money going to come from, let us show you where the money is going to come from. We just haven't had that private-public working relationship, which I think is needed in this property. Banyan Drive is suffering right now. We have crime, fires, homeless. Every day we have crime in front of the Nani Loa. Police are called weekly. Our tourists in the Nani Loa are being impacted by properties that are not being operated to the utility that they deserve for the people of Hilo and the state. And so my cry out here is, let's do what's right. Let's do what's best for the interest of the state of Hawaii and the people of Hilo. And you know, if you don't want Tower to do that, I'm okay with that. I want to do what the state wants me to do. I've never wanted to develop something that wasn't right. We're here for legacy projects. Here's my fear. If we don't defer this to get into details on how this can work as a private-public partnership, if we just cancel it and don't go into the details, and by the way, I'm saying defer, and I'm still open. If you want to cancel it later when you get into the details of how it would work, great. But don't just throw it in the trash can when you have somebody here with more heart on Banyan Drive than anyone has shown for 20 years on Banyan Drive. He's sitting right here. Stuart Miller, president of Tower, Noel Ross, who just was nominated for an Emmy. We're all here to help. So I'm asking for a deferment so that that process can take place. What are we in a rush for? Question, did we not start this in 2016 when I made a proposal in 2016 to renovate Uncle Billy's? Then BLNR was awesome to go to an RFP process. Mahalo, thank you. That's the best thing for the interest of the state. Why spend the state money when I'm willing to? And when Tower's willing to, and when the owners of the Nani Loa are willing to. So here we are. We're asking for that deferment to allow at least consideration of how you could help the state of Hawaii get this done quicker. We're fearful that if this is canceled, in 4 years from now, we will be seeing a Uncle Billy's with 10 more fires. What if one of those fires impacts our hotel? What if it injures people? We need to take control of this asset, start managing it again. When we managed the property, there were no fires. We had security. We walked the property 24/7 with security. We managed it properly, and we were willing to do that right now again and do it right. But we weren't getting a working relationship in the best ability, and we're asking for that. We're asking for deferment and a working relationship. And I would like, Chair, to maybe not testify anymore, but ask for that interview with the committee and talk through the details of how it would work with Tower and where the money comes from and where the loan is and what Hilton is backing to do a hotel here, and have all those people in the room. Hilton, the lender, everybody there to provide this solution, rather than, if you cancel it, who knows how long? Maybe it took 5 years to get to this point, and now we're saying, oh, well, maybe it's another 5 years after we cancel it before something's done. There's no guarantee. The BLNR can't guarantee the state will have the money ready and available. So why not at least defer it to get into the private-public partnership analysis that has not taken place? No one's ever called me and discussed, well, how will it work? How will you do this? I can commit we'll do it just like the Nani Loa. We committed to put money into the Nani Loa to bring Hilton there, and we are committing to BLNR to bring the money to Uncle Billy's and Country Club, just like the Nani Loa, just like Tower did when he rose its hand by itself at the bankruptcy. We're committing to do that for Uncle Billy's and Country Club. The selection was right. It's in the best interest. I don't think we should just throw it out without deferring and having time to have BLNR and the committee understand exactly what we would do for BLNR and DLNR and doing a new ground lease. We're really afraid that we're the only parties with a vested interest owning the Nani Loa, and no one really cares that the weeds are growing over to the Nani Loa right now, and the weeds are fires, crime, and everything that's happening, and everyone just doesn't understand that the Nani Loa is suffering because of that. When we had Merry Monarch, we had to have extra security guards keep the homeless from coming into the Merry Monarch festivities because Uncle Billy's is a festival for that. So I just plead and ask for a deferment so that adequate review can be done rather than just giving up. There is nothing that stands in our way to do this.
Thank you, Mr. Bushore. Mr. Char.
Madam Chairman, items 2 and 3 are related, and also item number 9. And rather than taking action on number 2 at this point, I wonder if there's some way in which we can put all 3 of those items together for determination. There are questions that I have of Mr. Bouchard, but probably more efficiently if it could be handled in composite.
Yes, we can do that. I have 2 questions before we move on to hearing the presentation for D3, Mr. Bouchard. There was a mention in the submittal of a lawsuit from one of the members of WHR against you and Mr. Miller, alleging that the proposal was a violation of the operating agreement. Can you tell me the status of that lawsuit, please?
We are in receipt of the settlement agreement in the format that is to be signed. We have received that from Mr. Olson's legal counsel, and all I have to do is sign it. I am not going to sign it if his false statements in the newspaper that the operating agreement doesn't allow it. The operating agreement expressly allows it, and I can testify to that under perjury because I drafted it with my lawyers. It says very clearly if we want to develop Uncle Billy's, we have the right to do so. And so in any event, we have got peace with Mr. Olson. Mr. Olson has said, well, just let's have a settlement and go our separate ways. And so that could be a condition of your deferment, is that you could condition that that settlement is shown to you and it's signed by both parties. And so that's all gone away. In my mind, we just have to settle it and sign it. The reason I haven't signed it is because it is false. And if that's the basis or part basis of us being terminated on this on a false claim, it's not going to go well because it is a false statement. And I have the operating agreement to prove it. I can show you the provision right now. I can pull it out, show you the signature, and show you the section that says it. And I'd be willing to do that. So that will be resolved, though. It's over. We just need to sign it, and we have received it from Paul Alston, Mr. Olson's attorney. I've always loved Mr. Olson. I always say, hey, you can't have two Eds in the room, especially when one is more senior. And so I defer to Mr. Olson and say, hey, let's just go our own ways in a positive way. And that's where we are today. So it's all positive now.
Thank you. And my other question is, I understand that some information was asked with respect to your proposal, financial information and financial documentation that you didn't provide. Is that correct?
Well, I've never been asked for that information when I signed a lease assignment with you in 2013 and 14, and it committed $40 million to improve the Nani Loa. We don't release tax records. We don't release that stuff to the public domain. We released information adequate to show you we're the most qualified party. And we have the financial wherewithal to do what we are saying we are going to do. If you need more qualification information, it's not related to taxes. It's related to where's your commitment of the $20 million of money to put up a new hotel. Well, I can show you where that money is. You didn't ask for that. You asked for tax returns, which are irrelevant for the $20 million that is in the future. We have the commitment to build the new hotel. I can supply that information, but asking for tax returns is irrelevant. And I would never release my tax returns to a public entity. That's just not appropriate. It's a lot of personal information in tax returns, and it's just not something that goes in the public domain. I apologize, but if you want the commitment of where the money is coming from and where the loan is coming from and where the equity is coming from Tower, we're happy to provide all that.
Okay, thank you. Russell, why don't you go ahead with D3, or Kevin, I guess?
Okay.
I agree with waiting till we hear all three. But before we left Uncle Billy's, I wanted to ask staff another question. Do we have security there now at Uncle Billy?
Yes, we now have a contract back in place, and the security coverage is not 24 hours a day, it's 12 hours a day. And the coverage, it's like a staggered, they don't have a set start time so that people in the area don't get a sense of the schedule. Yeah, it's staggered.
Okay, good. We at least, they do a sweep and make sure that nobody is set up inside the building.
Right.
Okay. All right.
Well, I don't know how much they actually go inside. They're mostly posted, outside, walking around. People aren't congregating there, but it's really not safe to go inside the structure.
We don't have any actual condemnation order from the county.
No, all we had the letter. Sorry, yeah, we just had a letter from the mayor in 2017 saying it's too many violations, not safe for lodging, stop using as a hotel.
Because the county can actually force us to tear it down, right?
Yeah.
Okay, thank you.
Okay, D3, Kevin.
Oh, sorry,
Oh, sorry.
Chair, one question. Kevin, did we ever ascertain cause of the fire?
So we haven't received the official fire department report. And I think until we have that, we can't really say, but it appeared to be intentionally or negligently set by somebody who wasn't authorized to be on the property.
When are we expected the report?
I just checked with Gordon last week, and I don't know if we have an update, but I can follow up with him.
Okay, thank you.
Okay, D3.
Okay, D3 is for the country club RFQ, RFP, and I won't repeat most of the facts because they're the same for both items. I'll just distinguish the country club property is still occupied. The board approved a revocable permit to the tenant who's been using the property as a apartment hotel. And, so that property is occupied. We're receiving rent from it. The architectural study on that report, actually, the first recommendation was to demolish it as well, but the current tenant has put some money into addressing at least life safety issues. So we don't have any county order directing it to be shut down. It seems to be usable. And in view of the legislative action on getting funding for the demolition of Uncle Billy's, we think there may be a chance of trying to get some money to do something with Country Club as well. So the recommendation is the same as Uncle Billy's. We would cancel the RFQ, RFP for this property and rescind the board approval from 2019. Thank you.
All right, questions, board members?
Well, this one is different than Uncle Billy's in that we did have another applicant.
That's correct.
What has changed? I mean, if they had been the only applicant, what would we have done? What would you have recommended back a year ago?
Yeah, you're correct. So we did have 3 applicants submit proposals for this property. And the evaluation committee looked at the 3 and picked Tower Development as the one to recommend to the board. They actually notified the other 2 that they were not recommended for selection. It's because of the financial situation behind Tower Development. just that we can't recommend that we proceed with selection for this property.
Well, you're asking us to rescind this. Are you asking us to rescind the total concept of going under the RFP, RFQ? Or are you asking, see, the board never approved the committee's recommendation. We deferred, all right?
That's good. Well, yeah.
So what are we voiding the whole RFP, RFQ process for Country Club as well as, you know, we don't have anything. Is that what is being requested now?
Yes, and so it wouldn't prevent us from coming back, you know, to do an RFQ, RFP just for this property, but we're thinking of, it's better to take an area-wide approach, you know, to Banyan Drive instead of maybe just doing this Country Club by itself.
Well, I'm just wondering about that because I'm back to about, you know, here we are a year later, but we had an RFP, RFQ. There were these 3 applicants. They picked Tower as the best of the 3. And now the committee is saying, well, we want to unpick Tower. And does that mean, I'm not getting why we're giving up the RFP, RFQ completely?
So
the committee, you know, if Tower was, if we had 3 good proposals and Tower was the best of the 3, and we didn't like Tower, you know, or even Tower dropped out, wouldn't we look at the other 2?
So I think if I can answer in part, it's the way we structured the RFQ, RFP. If you look at it, it doesn't really say you pick a first, second, and third and rank them that way. It just says make a selection, and so that's what the evaluation committee did. It turned out that the one selected, you know, it doesn't seem to be financially capable to proceed. So it is asking for cancellation of the process. The other thing is I mentioned, I'm sorry, the architectural study for this building was actually demolition, the first recommendation. So we might need to take a closer look at that.
Yeah, I'm really not getting why, assuming that, let's take it for granted as granted for the moment. You know, I'm not prejudging this, but let's just take it for granted that Tower is not in the picture. All right, I'm not getting why that means that we abandon the idea of an RFP, RFQ, or even the one that was authorized earlier, rather than saying the selection committee looks at the other 2. And, you know, I don't know if their proposals have expired, they're not interested anymore. And it may be that the selection committee could tell us that we don't like either one of these. You know, that's
well, Chris, let me ask this, Kevin, this. So if the RFQ, RFP was canceled, that doesn't prevent any past applicant of applying again, correct? Is that correct?
Yeah, if we cancel it and rescind the board action, we would need to come back and ask to do a new RFQ, RFP. And in that case, there would be nothing preventing anyone from resubmitting.
Okay. You know, and in my mind, you know, a lot has changed over this time, right? I mean, if COVID taught us anything, right? I mean, we're now talking about rejuvenative tourism. I think there were 2 acts that are germane to this in the 2021 session. One was 236, the other one was something like 221 or 222, which completely, in my mind, changed the game and the way and manner in which the RFP, RFQ can be developed and written and put out to new prospective bidders. So it's not like the conditions have not changed over time, right? I mean, there has been a significant evolution, to the development out in this area. So I just wanted to say that, Chris, because I think we keep going back to this original RFP, RFQ, but it doesn't prevent anyone, original or otherwise, from applying again.
Well, it does, if we take the action today, it does mean scratching the 2019 action. And then department has to come up with another RFP, RFQ, or else we live with the status quo of the property being under an RP for a really long, or whatever length of time, or we close the building and go in for a demolition. And I don't really like either of those two alternatives. I think it's a viable building. I think it can be fixed. Been through the building.
Can I speak on D3 at all?
You will in a minute. Let's finish our discussion here, and we'll go into a public testimony and your testimony on that. So I'm still. I mean, it was only, it wasn't. Then the department, the land division brought us the approval of the selection of Tower to do the RFP less than a year ago, well into COVID. These legislative acts have not changed. I don't think that there's a sentiment among our legislators or the public, even in Hilo, that they don't want Banyan Drive as a visitor center. I mean, I think that if we're going to have visitors in Hilo.
Well, I don't know about that, Chris. I don't know if that's a fair statement. Until we have some kind of report that substantiates that. But yeah, I'm just perplexed. If this is not prohibiting a new process, what's the deal? What?
Well, it is a fair amount of work to get into a new process, and I haven't heard land division saying that they're wanting to rework the RFP, which was pretty open-ended. I mean, if you're going to do an RFP, I think it's going to wind up looking something like the one that they had. And if you,
I disagree with that. I disagree with that because I think there are lessons learned in this past one. I mean, look at sea level rise. I mean, all of this stuff was not in there, right? I mean, and these things have to be thought out methodically and strategically if you're going to have sustainable development on that coastline, right? So I disagree with that. I think there have been substantial changes, and I think there will be substantial changes.
I mean, just to clarify, we have been looking at sea level rise, and I think it probably was included in. It's one of the studies.
It was included in
one of the studies. We did a sea level rise study, and it's a publicly posted document, and it is important for consideration of what happens on any of these parcels. And I think the thing about Country Club that's a little different is that it's not completely falling apart like Uncle Billy. So there's a little bit of breathing room time-wise. I mean, I think, Kaivi, what you're saying about, regenerative tourism, maybe there's an opportunity for a different design now. And also, maybe we want to clarify whether we are specifically looking for tourism approaches rather than residential approaches, which frankly, I think the tourism approach for Banyan Drive is more appropriate. That's obviously something that people can have different discussions on, but I'm not sure we clarified that in the RFP.
Yeah, okay, if I missed that, but I didn't see an option where there is a no development option, right, for very Mackay properties.
Well, like the tear down is the no development option.
Yeah, but then there's a follow-up to that, right? Like, oh, okay, well, we tear it down and then we develop something new there. Or
Well,
you just tear it down and.
or not.
make
I
it
mean,
park.
what's happening here is that this redevelopment process has been really unsuccessful for years. And so we did finally say, you know what, we should just tear the thing down. It's a safety hazard, which I'm talking about Uncle Billy's.
Yeah.
And, you know, ask the legislature for money. We're not successful. This year we were successful, but with a funding source that doesn't have adequate funding. So at least we'll start the process there. The end result of that is vacant space, which maybe is more appropriate for sea level rise. And, you know, maybe it's more park area. I don't know. And, you know, that could be where we are with Country Club in five years, certainly 10 years.
If I could mention one thing more, what to do with Banyan Drive has been extensively discussed in Hilo from before the time I was on the board, before the time I came back on the board in 2014, and there are committees in Hilo involving state people, county people, community people. And the basic consensus has always been that it is a visitor attraction area and where we want to have visitor accommodations. Now, there have been different iterations of plans site by site, but I don't recall there being any kind of push to have the Country Club site vacant. Uncle Billy's site, maybe there's been some issue with that because it's actually sandwiched in between these other buildings. It's a pretty small site. It's hard actually to do anything with that on its own. But I have to say, this is not something that we are operating in a vacuum here on the board on. This is a big community issue, and there've been lots of discussions, and the whole idea has been to redevelop Banyan Drive, not to take away accommodations. I know the visitor industry feels that you need to have more rooms there, and you need to have more rooms in Hilo. Difficulties in creating rooms elsewhere in Hilo, you wind up having to go to sites that have not been developed so far. And I think that as far as having rooms, the community acceptance is better, certainly in Banyan Drive than elsewhere that you could think of in the community of Hilo.
Chris, could I just, I think all of what you're saying is correct. The big challenge has been the cost of tearing down these derelict buildings. And so if you tear it down and then you have vacant space and you decide to move ahead, you probably get a lot more bidders and a much more like financially simple process, because it wouldn't have to involve a financing, basically private financing of a tear down, which has been an impediment to good designs. Or, you redesign the whole thing so that the shoreline is not where you have the new hotels, you have it in some other location.
Yeah, thank you, Chair. That's kind of what I was needling at. Last question for Kevin. Kevin, you kept saying the architect. I'm assuming that that's housed under structural engineer that's saying that the building is unsound, correct?
So we hired, the consultant we procured was Erskine Architects, and I believe they had subs under them for any, necessary professional opinions beyond architectural, but yeah, the conclusion of the report based on all the different things they looked at was tear down.
Okay, can you just verify that, later that there was a structural engineer indeed, and that Erskine Architects took the structural engineer's opinion on the matter?
I can, and I can also tell you, apart from the Erskine Architects study, we did have engineering studies done before we procured the architectural review, and that was in 2014. And I think we have it in the Exhibit 1 to the submittal. It tells you that the engineers estimated the remaining useful life of Country Club, I think, at 5 to 7 or 8 years in 2014.
Yeah, and that was a structural engineer, correct?
I believe so, yes.
Okay, thank you.
Any other questions? All right, Mr. Bouchard, did you want to provide public testimony on this?
Yes, just on D3, even though it overlaps with D2, I just want to clarify a couple things. People have made the word qualification an issue financially, and that's wholly unfair. When I took on the obligation to do the Nani Loa, we were qualified in the state. We've done over $1 billion of transactions in this state over 25 years. 1 billion. So if anybody wants to challenge qualifications, please just ask me to list them all and provide you the support that the committee needs, because that's just a wholly unfair way to go. Second, qualification. Since COVID started, we've doubled our assets from over 200 million to over 500 million just in the last 2 years under ownership and management. We now have excess of $500 million of assets. So this qualification thing, I just don't want to say anybody was wrong, but the committee should do a private-public interview meeting, and you go through this stuff in private-public deals. I used to be a lawyer in this process. That's how it's done. You sit down with a development agreement and you say, prove out how you're going to fund this, this, and this. And you say, well, we just bought $200 million of assets during COVID when no one could really do much. And so our qualifications now are double what they were 2 years ago. But people are sitting on this referencing qualifications, go to a second bidder. Now, it's nothing personal. I know you guys have to do your job, but we're more qualified now than I've ever been in the state. And so the other point I want to make is that we can explore both, Chris. We can explore sitting down with the committee and a private public and doing a process to continue it at any given time. If the state wants to turn Uncle Billy's into a park, guess what? I'll probably donate towards that. If that's what the state ultimately wants, you don't commit to me to develop it. You commit to me to work in a private-public partnership. And Mr. Yoon's comments are right on. We spent hours, Mr. Yoon, on sea level rise in our bid and how we would create the hotel to make sure that that's covered. No different than Country Club, where parking is on the lower level so that all the rooms are above water. So if you do have a little rise, you have a tsunami, you have anything, you have to protect your customers in the hotel business. So we did give a lot of consideration to that, and you're right on that has to be in the forefront of the developer's mind to work with the state to ensure safety, and we would do that. And the third factor that people should be reminded of is that in order to develop these properties, the current codes require parking. And there is no parking adequacy unless we donate land from the 70 acres of the golf course to, which we control under our lease, to allowing a lease or a license or use of our parking on the golf course property to Uncle Billy's and Country Club. And then I also offered Mayor Billy, Mayor Kim, and Mayor Roth parking for Reed's Bay, that we would donate unused land for that parking out of the golf course. We're a good neighbor who wants to work in a private-public partnership and explore it in the future, but we're not asking for a guarantee. We're asking to explore it so that we can uncover how best to serve the interests of the state. And that's why I'm asking for a deferment, because if someone's concerned about qualifications, then let's talk about that at a committee level or at a personal meeting between DLNR and the developer. That's what you do when you move to the next stage. You get the verifications. You're not signing a development agreement and or a ground lease until all that's done. That's the next step. That's why you picked us, because you knew that we committed to do the Nani Loa, and then we went out and did it. And we're going to do the same with this. Well, my commitment is not to make money. My commitment is to improve Banyan Drive for the people of Hilo. We have become so close with the community. And I'm there at Mary Monarch, and they say, when are you going to help us with Uncle Billy's? Everyone in Mary Monarch is asking me that. And I say, as soon as DNR allows us to. And so we're not asking for a guarantee, and I'll put that in writing. I'm only asking to work with the private-public partnership to pursue it and defer this so that you're able to see all of the things that you're uncertain about. And if the state wants to turn that into a park, we do that too. But to cancel it is to say, let the Nani Loa be subject to a mess on both sides for the next, I don't want to be negative. I don't want to say it'll be a long time, but you can only guess that it's not going to be next year that this all gets resolved. The crime in Country Club is very bad. Drugs, the whole gambit of mess over there that spills onto our parking lot at the hotel, stealing tires for drugs. It is a mess over there. We need to help DNR any way we can to secure these assets and reduce the crime, go back to 24/7 security, which we used to do. We need to work in a private-public partnership and defer the final decisions to later. You don't have to cancel. We should be saying, let's go a little further and make sure that we're exploring everything that benefits the interests of Hilo, the people of the state of Hawaii, because you have a team here that has a vested interest in the Nani Loa, that we have a new loan of $62 million. Nobody is going to give and have me personally sign on a $62 million loan unless my financial statements and my tax returns validate that I can sign a $62 million loan. Not too many people have ever signed a $62 million loan. I'm about to, and it's based on the fact that I'm qualified. And so I come to you humbly. But you also need on the record that you're making a decision knowing that. So I would never say what I just said because I'm too humble for that, but I have to say it so it's on the record so you know there's someone qualified because I'm signing a $62 million loan. And Uncle Billy's is probably a $15 million loan. And Country Club might only be a $10 million loan. Certainly I'm qualified to do those little deals. I call them little deals compared to what I'm used to doing. So I do humbly ask that we don't talk about ourselves in news. We don't gloat. We live here permanently, and we just want to help the community. And giving it all up and canceling is not the right decision in the interest of the state. Processing it, getting any answer you need is the right answer, and terminating it later, so be it. But do not think that we're not going to be hurt on Banyan Drive if this is canceled. We're going to be hurt. It's going to hurt tourism. The negative news of cancellation in itself is going to be, oh, you're kidding me. Hilo needs this. The people of Hilo need this. So I do plead to defer it, get more answers to uncertainties so that BLNR can make a great decision in the end and do right for the people of Hawaii.
Thank you. All right, any questions, board members? Mr. Ewan?
I have just a question. You talk about doubling the assets, doubling the assets. Do you mean Tower Development, Inc. or some related group of companies, if you could be more specific about that?
So every piece of real estate in the institutional level, like when you buy an apartment building, requires an SPE, a single purpose entity, and Tower is the manager of those SPEs. WHR is an SPE. You can't obtain loans unless you have a SPE, special purpose entity, right? So all real estate at the institutional level of a hotel or otherwise is owned by an SPE. And the manager and the owner of that is the managing member, which is Tower. So every one I speak of is related to assets where we have a SPE that is managed by Tower. And no different than Uncle Billy's. Tower would sign the loans, be responsible personally for the construction loan as manager, but Tower, the name of that project would be called Tower Uncle Billy's LLC, if Uncle Billy's would let us use the name, or it would be Tower UB Banyan Drive LLC. Tower would be the manager. That's how all real estate, hotel, apartment buildings are owned in the state. That's how every private transaction is done. And so when I speak to that, that's what I mean, Chris, is that we're the managing member, we're the manager, we're the investor too, along with our investors that are partners of ours in the ownership of that SPE, Special Purpose Entity LLC. So yes, we've doubled that number since we started this RFP process. And I'd be happy to show you those properties, those apartment buildings in Honolulu that we've acquired. And so be happy to show you the expansion we've done in the last couple of years. But again, we need to keep sight on what's most important for Hilo right here, and that is to have someone who cares. I believe I care more than anybody else in the RFP process other than you. I know you care because you're public servants, and I thank you for all the hard work to do this over the years. But I personally care for the people that are my personal friends in Hilo. So we have a duty to honor those citizens that live in Hilo and help have another restaurant on the water or a hotel or an apartment project, whatever you deem appropriate to go there. I'm not going to pick it. I'll just help get it developed on a private-public partnership arrangement, which we thought this was, and we still want to continue. And I'm happy to supply that additional information on qualifications if the committee needs specific questions and answers on those qualifications.
Okay, any other questions on D3? If not, let's move to D9.
Board members,
I
Russell
think there was someone's been waiting over an hour to testify on D2 and 3. We probably want them to leave, Chair Case. We don't want them to hang out for D9. Can we let that public testimony be done?
Who is that?
Ryozo Ariyoshi. He signed in late. He signed in at like 9, but he showed up in a beautiful looking suit.
Go ahead, Mr. Ariyoshi.
My name is Ryozo Ariyoshi. Thank you for providing me this opportunity to speak to you. With all due respect to the BLNR Chairperson, Suzanne Case, Compliance Officer, Gordon Height, and board members, I humbly come before you to plead with you to be fair and simply do what is right on an important matter that will be good for Hilo and the Big Island. Regarding the Tower Development's RFP for former Uncle Billy Hilo Bay Hotel, it has become evident through reports provided by Erskine, DPW, and other reference reports that the building facilities are degraded and dilapidated due to neglect by former lessees and are in various states of disrepair and deterioration, and that regular maintenance and repairs were not done, or if at some points in time addressed in the past, done so with non-conforming violations of code, non-permitted, and minimal Band-Aid solutions. It was surely a blessing that a developer like Tower Development came along, offering and pledging to provide resources for redevelopment and full renovations for existing buildings, and in the process, beautify Banyan Drive, and do so with careful and sincere sensitivity to the Hawaiian culture and protection of shoreline and coastal waters. This project will also stimulate economic growth in Hilo and provide many jobs for our local residents. In addition, our development has made many generous concessions that benefit the community, including offering to pay for demolition and redevelopment costs, granting 1 acre of parking for Reeds Bay Park, grant of trails to Naniloa Golf Course for Hilo Bayfront Trails, and dedicating the golf course to DLNR and the county for cultural, hula, and public use. The developer has exhaustively worked 5 years with DLNR on the RFP and met all DLNR requirements, including providing executive summary, site plans, operation plans, marketing feasibility analysis, demolition and repair costs, schedules and timetables, project cost estimates, and financial pro forma. As a result of such earnest, sincere, diligent, thorough efforts and hard work on behalf of Tower Development, the DLNR had approved Tower Development's RFP and in fact have already submitted awards. However, recently it has come to light that after all this 5 years of work has been done, DLNR is now considering pulling back its RFP. I believe this is very unfair to do so in the interest of the state, and humbly and respectfully plead with DLNR Chairperson Ms. Case, Mr. Height, and board members to please allow the RFP to stand, continue its approval. This is the only fair and honest thing to do now. Mahalo nui loa. Thank you.
Thank you, Mr. Ariyoshi. Do you have a particular business relationship with Tower Development or WHR? I'm curious about your support for them.
I have known Ed. I'm in commercial real estate, and I have an RCA team that we recently expanded to continental U.S. So I have known Ed as a friend, going back from a lot of his projects, including the Wyland Hotel on Kuhio Avenue, and I have the Naniloa, and also recently the projects on Kauai and the Big Island, Manalani luxury homes. So I keep in touch with a lot of developers and redevelopers, and also look at a lot of projects. So I've always, I have, with each project, I not scrutinize, but I always look at and evaluate projects. And I had seen vision in his earlier projects. So that's my main reason of support, is that I've seen his great vision in his past projects. I do see it. I did see it recently with the Naniloa, and again, I see it with this project.
Thank you. Any questions, board members?
Sorry, to follow up on that, Chair. So are you saying, Mr. Ariyoshi, that the answer is no to the chair's question? No, there is no business relationship?
Not in this project, no.
Not on this project. Okay.
Okay, any other questions?
I'm a real estate, commercial real estate broker. So I have a lot of relations and work and business with redevelopers, all the way to LA, Las Vegas, all the way to Dallas, Texas. So I look at a lot of redevelopment projects. And also, our network of investors are global, including content to US, Asia, and locally also here in Hawaii.
Member Canto?
I beg your pardon?
We can't hear you, Ms. Canto.
Can you hear me now?
Yeah.
So I'd like to thank Mr. Ariyoshi for his testimony and his support, and your passion for Hawaii in general. But thank you so much for your testimony. Aloha.
Thank you very much for giving this opportunity to speak before you. And I'm leaving a copy of this testimony with the BLNR.
Okay, thank you.
Thank you.
All right, D9.
Okay. Good morning, board members. Russell Tsuji, and I'll be presenting this matter before the board. D9 is the staff recommendation to the board to deny the instant request. And the request is to further mortgage and borrow money out of the Nani Loa Hotel up to the tune of $62 million. As stated in our submittal, I think we repeated many times, this loan is a bailout loan in a distressed real estate situation. When I say distressed, it's not under threat of foreclosure, but in a current foreclosure action with a pending motion for receivership. And what that means is the lender has filed a motion seeking court approval to have a third party, sort of like a trustee, involved in making sure the revenues collected from the hotel operation are paid in accordance with priority, whether to the landlord as lessee of the state of Hawaii, whether to the bank who has a first mortgage on the property. As noted in our submittal, we received the completed application for this loan request in the evening of May 17th, seeking board approval before the end of the month. At that time, we were shooting for the 27th, which was last Friday. Myself, my staff worked diligently within the next 48 hours to turn around a submittal and get the item on the board agenda in time on the 19th, which was posted. Unfortunately, we were not able to, the board meeting was canceled, and which is now being scheduled and heard today. Aside from my comments in the submittal about what I see as being a bailout type of loan in a distressed real estate situation in rising interest rates on a very short-term loan that is adjustable, in my understanding, as I reviewed the application, it looks to be adjustable at least every 30 days. In this situation, all we see is interest rates skyrocketing up, what does that mean from a mortgage standpoint? Higher payments. We have a situation with a lessee who has historically had some issues keeping current on our existing lease. As recent as a year ago, we came before the board on a major default situation over a year's worth of rent, over $500,000. And this board allowed a short extension after the board meeting, and the lessee, granted, did pay it by the deadline set by the board. Apparently, what happened is, it looks like, at least from what I can see, is he did not pay attention to the mortgage, which and later ended up in the current foreclosure proceeding. From a lender standpoint, and I used to be a lender in my prior life, we call this pyramiding. It's a big red flag in the lender industry. It's borrowing from Peter to pay Paul. Borrowing from Peter to pay Paul. Other people's money. In effect, looks like that he paid the state lease back in a year ago, but again, did not pay attention to the mortgage, which ended up in default. Now we're in a situation where the mortgagee has foreclosed. The application from council that I received Tuesday evening on the 17th indicates unless this board approves this loan, and the loan is closed by May 31st, I am told, the lender will pursue and meaning further initiate the foreclosure proceeding and or go into bankruptcy. And that is from what we've been told. So we presented that before the board and to explain staff's recommendation why we don't believe approving it is in the best interest of the state, which I believe is the question before this board, is what is in the best interest of the state. We currently have an asset, a public trust asset in Hilo that we've allowed to be encumbered with a leasehold mortgage. The lease is very long-term, has another 50-something years to go. Initially, I think Mr. Bashor, when he acquired it out of bankruptcy, he himself acquired it out of bankruptcy, initially took out a loan for $20 million. And from what we could see, majority of those monies went into the hotel. Unfortunately, in 2018, he further mortgaged that property. And it appears he was able to take out $30 million. And staff inquired where was the money going. Mr. Bashor refused to disclose that. We reported that to the land board, but notwithstanding our report, the board consented to that mortgage. So now we're in a situation where we have a $50 million loan on an asset with $20,000 worth of improvements that was put into the bill. You're being asked to further allow a mortgage, another 62 million. So that, and we roughly calculated the balance was roughly looked like about 50 to 48 million. There's about 12 to 14 million in between, probably from delinquent interest, penalties, attorney's fees, court costs. But the explanation that we got for the loan on the application was the existing loan has gone into default due to losses that the Grand Nanihoaloa Hotel experienced during COVID. If the new loan does not close by May 31st, I am told the existing lender will pursue foreclosure and begin bankruptcy proceedings on the lessee. I think a lot of our tenants did experience hardship. Some even experienced losses during COVID. This is probably Naniloa, and if I recall correctly, this is the only tenant on Banyan Drive that has been before the board on these lease defaults. Most times you expect the lessee, to the extent possible, to cover those losses internally. In this case, it looks like he will experience losses, but also did not pay the bank the first mortgage on the, which is encumbering the leasehold on the state asset, which has now jeopardized the state situation. I believe that whether we're in foreclosure or whether we're in bankruptcy, it is better. Well, I shouldn't say better. It's probably worse to be in a situation with an asset, the state asset, having $62 million encumbering it versus 50 million. And that's why we're recommending, we just don't see a way out of this. We think it's expressed that this is a bailout loan. There's no future. It's a short-term loan, 2 years. Even the lender is not willing to commit. And the lender is not willing to commit at any rate that is other than adjustable and actually, in my opinion, a very high rate at that. Again, I think it's better for the state in the best interest of the state to stay the course in the existing situation with the existing mortgage that was allowed and not further allow another very short-term mortgagee to come in. Because at the end of the day, we're going to be in a situation, I think, very similar to today, except in a situation where the lender has a higher debt on the Nani Loa Hotel. I'm available for any questions, clarifications if you want. And I'm sure Mr. Bushores wants to present his case. Thank you.
Okay, any questions? All right, Mr. Boucher, you want to go ahead and testify?
Yes, Bashor on behalf of WHR LLC, which is a special purpose entity, and SPE, Hawaii Limited Liability Company, which DLNR has approved the assignment of the ground lease to WHR after Tower acquired the rights to buy property in bankruptcy in 2013. And for all that, we're grateful. We've had great success. Everybody knows of the success of the Nani Loa and on the positive impact, so I'm not going to go into all of that. That's known. What I will tell you is in March of 2020, the Nani Loa reached its peak and was doing spectacular until March 13th. And COVID hit. I am not to blame for that. The state didn't give me any money to lose $13 million over the last 2 years. The federal government helped us a little bit with PPP, and very important for the board to understand is that while every other Hilton closed, I said I could not close for the people who worked. I'm staying open. And because a lot of those people I hugged every day, they were like my employees. That came with a huge cost and huge losses. But and it's very important that DLNR has lessees that do the right thing, not just the selfish thing. And I will plead that to death because Lord watching over, I answer to him daily. And what was the right thing to do was stay open, incur more losses, keep the employees hired, pay them, never let anybody go. And we did not. COVID is to blame for my new need for a new loan, not me. I didn't do anything wrong. I just kept everybody hired and incurred significant losses. But I do want to remind the board that we were doing great before. The defaults that Russell mentions, I admit one wholeheartedly that, yeah, when you lose $500,000 a month, I mean, that's not even fathomable to even look at a bank account and see $500,000 negative a month and be able to stay open, be able today to say, does DLNR have any defaults today, Russell? The answer is no. We came in here months ago and asked the chair for a big favor. Hey, we're coming over the hump. Could we do monthly payments for 6 months? This board honored that and said, you've done your best. We'll go ahead and give you that 6-month process to get over the hump. Within 30 days, we had such a great month in cash flow. I disregarded the extension for 6 months and I just paid the whole 6 months that month. I could have delayed it and just kept paying monthly, but that wasn't the right thing to do. The money was in the bank. So example after example of doing the right thing. Now I'm put in a position to do something that is also the right thing, and that is We went to market with an investment banker across the United States to get a loan to cure all the outstanding amounts, which are in excess of $11 million to the lender. The current lender is owed $11 million, give or take. And we're now in a position where we have a lender who will say, yes, hey, we'll let you get through this hump because the hotel is doing so fantastic. They're not giving this money because the hotel is not doing fantastic. Before COVID hit, and these are very important numbers, they're confidential numbers in the sense of our competition, but generally speaking, the most we ever did, let's say, was $4.8 million of revenues. You have the revenues. You've seen what the most we've ever done. And in the last 12 months, let's say we've done $6.5 million. So we've done almost 2 million more revenues of EBITDA in the last 12 months than the history of the project. How did that happen is very important for Russell when he does his analysis of whether this is a reasonable loan, which is the standard that chair is required under the lease to look at and say, hey, is this lease reasonable to consent to? Or is this loan, this loan reasonable to consent to? Well, the revenues now support this loan. If the revenues were $3 million and we're in COVID mess still, we would be in a huge mess. God works in funny ways. He makes us lose $11 million plus and then says, hey, I'll supply a loan to take care of this problem, get you out of foreclosure, never have a default with DLNR after COVID, be on your merry way, and let us get through the next 2 years of, we have the worst circumstances. And you look at us and say, are we doing everything we should? We got a war, we got interest rate increases, we have market crashes on the New York stock, but we have a lender, which is one of the biggest ones in the United States, that says, tower development, by the way, I'm signing a $62 million loan, and I'm on the hook for some of that. If I didn't believe the hotel would fully support that loan in the future, I would never sign it. I'm not going to have them come after my personal assets. So is it reasonable for me to sign this loan? That's the first question. Not chair, not DLNR, but is it reasonable for me to sign this loan? Yes, very reasonable, because I'm going to ensure that the employees continue next month. I'm going to ensure that our 90% occupancy right now today is going to occur the next, and keep the economic stimulus of a Hilton DoubleTree in Hilo unimpacted by COVID. We cannot let COVID bring Hilo down. I can't allow that. We've worked so hard. So now that we have gotten through it and we're having record revenues every month, we have record revenues to allow for a $62 million loan, then the next very important question that everyone on the board should know is, where's the money going to for that extra, $12 million over $50 million of the last loan? Well, every penny of it's going to this last lender who is charging us. You will not believe what they're charging us. They are charging us on $4 million of late payments, over $7 million in penalties, which we think is, obviously completely unfair. But the feds protected the airlines. The feds didn't protect the hotel companies. If they would have just added in a piece of legislation that said, hey, you can't be unfair too much with hotel owners, keep a default interest at 20%, not over 150% default interest. That's what I'm bearing right now in order to keep the hotel on a very positive revenues, very positive employee status. We had a little rally with the employees a month ago. I showed up at lunch. They're all excited because the tourism is back. They're smiling again. They're all working hard, and nobody works harder than the Hilo employees. They are the hardest workers. And so here we are. My option is to do a new loan. I don't have another option. And by the way, that is not all that's happening here. $4 million is coming in from the investors, partners. it is a total of $15 million, 11 to 12 million, and the numbers are rough, but they're 11 to 12 million that go to the lender, and then another 4 million go to procure the new loan for interest reserves and real estate taxes and insurance and all the new loan requirements. So we are putting $4 million more into the hotel. No way would we be putting $4 million into the hotel if we thought someone was going to take that $4 million in 2 years. The revenues are great. We're excited. We're happier than we've been in 2 years, and we have this great result to allow us to not have any negative impact with a new closing of a loan, no impact, foreclosure is gone, bankruptcy risk is gone, and everything is hunky-dory post-COVID for the benefit of Hilo to continue in a positive fashion. If I had another choice, we be presenting it to you. We do not have another choice. And so the question is it reasonable for Ed to do this for the property, Hilo, its employees? The answer is absolutely. It's reasonable and it's responsible for me to do that. Now, I humbly ask BLNR to understand the circumstances that we bear those losses. We have lost that money because let's say we sell the property, one day, and let's say we sell it for $100 million. Well, guess what? We lost $11 million to this bank because of how they're treating us in COVID. We did lose because of COVID. Well, no sweat. No big deal. We're not greedy. We're just going to move on and do what's right and responsible, and that is to cure the past and be in the present and how to maintain a positive hotel for the future. So I do leave it up to the board and chair to assist us because we haven't taken a penny out of DLNR. We haven't asked for any deferral of rent, reduction of rent. We have paid current through COVID, which if you asked me when COVID started whether I'd ever be able to do that, Chair Case, I would have told you there's a 50-50 chance I could ever keep rent current in May of 2022. I don't know if it can happen. This has been a full-time job all over again to ensure the success of this hotel and to recover out of COVID. No one else takes that pain except Tower. I mean, every day we have to figure out how to make sure DLNR has all its lease payments paid. And now we have an obligation to cure the lender, even if they're being unreasonable and asking for 150% default interest. I have to be responsible and I have to cure that. And we have to go to the next state. So we are asking for a mere consent, which has no impact on the value of the leasehold lessor interest. It only has impact on our interest. So it doesn't cost DLNR any more money. It doesn't risk DLNR right now. There's no impact on you. We lost $11 million. DLNR didn't lose anything. We met our obligations under the lease. So yes, we are asking for a mere essence of help out of really 2.5 years of really tough problems and pain that we have overcome with record revenues in the last, few months. That on the books through the summer, everything looks great. We're excited. There's no negative news on the horizon other than, world war risks of Russia and Ukraine going beyond the borders there. But here in Hilo, we are ready to move forward to the next positive state with positive revenues. And we can't do that without a consent. We will be forced into foreclosure. Instead of having the foreclosure settlement signed off and gone, we will be in foreclosure if we can't get help from DLNR on this. We have no other choice.
Thank you. Okay, board members' questions? Chris?
Yes, Mr. Bashar, I want to start saying when I first got back on the board in 2014, my main interest was in seeing Tower complete the renovations of the Nani Loa. And we pushed hard on that at the board level. And you finished the renovations and your company did an excellent job on them and has made the Nani Loa a much better hotel, certainly, than it was when you took it on. And I certainly appreciate your keeping your employees on during the pandemic, and that I'm amazed that more of our tenants did not come to us for relief with the obvious problems the pandemic was going to cause for them, and that is undoubtedly the reason for your being in this situation. I do have to ask quite a few questions, though, about this particular transaction that we're being asked to consent to make sure that we are fulfilling our duties to the state in doing this, regardless of your past record. I've tried to support Tower on the previous relatively minor requests that Tower has had for adjustments from the DLNR. First question, you gave a figure of 6 million a year in revenues, which I thought was gross, 6.5 million in the last year in revenues, which I thought was, you were talking about gross revenues.
That's net.
It's net revenues. All right. Okay. That because you're.
So we went from 4.8 to about 6.6. So almost 2 million more per year.
All right. Because the reason I was going to question that is that your attorney's letter indicated that you had in excess of 6 million in net revenues to cover the new loan that was.
Which is the exact number we believe is about 6.6.
The net revenues.
Yes.
Cash flow.
Yes.
That's positive cash flow from the
yes.
building,
yes.
Not including, depreciation, deductions, anything like that. Okay.
Right.
Let me ask you a question going back to 2018, and for better or worse, I wasn't at that meeting when the previous loan consent was allowed. And Mr. Tsuji raises an issue which he raised then about 29.5 million being taken out in excess of what was actually needed to retire the previous loan. And I wasn't at the meeting. I did read the minutes, and you said it wasn't that much. I mean, can you give us an idea of what it
yes.
what it really was? And
yeah.
I'm a little puzzled by the mortgaging, by putting a much bigger mortgage on this asset and the money going somewhere else, because it seems to me that your other investors in WHR must have had some say in this, that basically their asset is being mortgaged and apparently the money is going to some other enterprise.
Going to the lender.
It went to the lender? Could you detail that?
Oh, back in 2018 or
yes.
now?
Yes, back in 2018, yeah.
Oh, okay. 18 compared to now is a very good question. In 18, I believe that, let's say lender and construction costs and all that, I don't have the specific numbers on me, Chris, but I'll answer, and I'm probably off by $1 million or $2 million. I'm not off by 20. Is let's say 25 million of construction related. Some is construction, some is beds, personal property, coffee machines, and all the restaurant equipment and the restaurant improvements. And all that was somewhere probably close to 30. I'm guessing about 30 million. 22 maybe in construction and another personal property and beds and all that other stuff, about 30. And then some of the investors, when we refinanced, wanted to be out of the financial investment, meaning they wanted their money back. And so approximately, I'll say 15 out of the 20 million approximately was given back to some investors. And that's why we can say that, people that are in dispute with us, no names mentioned, they don't have a penny invested in the Nani Loa today, but they're telling me I'm not allowed to develop, but they have not a single penny in the Nani Loa. And I find that highly ironic. because now they don't want to invest in this 4 million that's necessary. We're putting in 4 more million, and they don't want to invest in that 4 million, and they don't have any money invested, and they want to leave. That's fine. But back in 18, there was approximately $15 million of investors who got their money back, in part out of the loan proceeds by investing in costs of the hotel. Like they invested. They invest the money in, and we bought beds or whatever we bought to open up the Nani Loa, and those people got their money back from investing in those things. Some people did not get all their money back, and they still have money in the hotel. The new loan, so if you just took 30 and 15, that's about 45, Chris. And let's say there's 5, and I rounded, it was probably $1.5 million to get the new loan and costs and brokerage fees and other stuff, legal fees and all that. So there's probably $2 or $3 million in that kind of stuff over the term before that, which are what I call soft costs, legal fees and all that stuff over the years. So there's probably a couple million of that, and then another million or so either was on construction or return of the investor money. But just roughly 30 and 15 returned to the investors. Maybe it was 16 returned to the investors, which was the 50 million, and the cost to close the loan was the total 50 million. So that's where the money went.
So you're saying there are people who are investors who are still entitled to some benefit from being on the operating agreement. So they were not actually bought out of the operating agreement, but essentially got their investment money back.
Yes, correct. Okay.
No, go ahead. You can explain. Continue to explain.
No, I was just going to say, so they'll wait until, let's say we sell the property in 10 years or whenever, then those investors who stayed in will expect and hope for that we have profit in the future.
When did you start going missing payments on the Wilmington Trust loan, the current loan?
We couldn't pay the April payment on 2020 because we had not a single person in the hotel. It was closed down in the sense of arrivals. We stayed open, paid people, but 2020 we could not pay. We had, I think, let's say $400,000 in losses in April 2020, and in addition to those losses, we had the $300,000 loan obligation to pay. So that month might have been a $700,000 loss, the first month of COVID.
And then I'm going to guess that you've been in negotiations with your current lender, and
yes,
a complete impasse on that.
They haven't given up one penny, Chris, of fairness. They're asking for, I call it highway robbery, and how the feds allowed that to happen, that anyone can charge these unbelievable amounts, because I see it as taking money out of them, taking money out of Hilo. But in any event, we have not been given one penny in reduction of their claimed default interest, meaning they're telling us this huge number, Chris, and they're saying we're not negotiating, and they're not giving us a penny. We have no reductions. Absolutely zero reductions. So we are paying 7/4, and we believe it's about 150% penalty. It'd be like you're 600 having to pay you for a year, your default. Be a great way to structure it, Chris. You guys make good money if someone defaulted, but we're going to pay them on our 600 one-year lease default. We have to pay them 600 in addition plus half, so we pay them $900,000 on 600 missed payment. We're paying them 900 over the 6. That's the penalty they're charging us. And the state and the feds didn't do anything about it to say that's wrong. We're not going to allow people to gouge COVID victims and COVID hotel owners. Now, I have to live with it, got to pay it.
Your attorney says, and I catch a hint of this in your testimony, that we don't, if the board doesn't approve this consent to mortgage, the foreclosure goes through, and then WHR goes into bankruptcy. Is that?
Well, I don't want to speak for, I don't want to speak for the attorney. You know, attorneys do their job to inform the board of what he might advise me to do. You know, I would fight those alternative options, you know, to death. I don't want this property to go into foreclosure, and I don't want this property to go into bankruptcy. There's no need for it. So I would do everything in my power to avoid those things. But lawyers are lawyers, and they have to put on the record what the risks are, and so they're informing you of the risk. But certainly, I'm going to do everything in my power to avoid that. And by the way, it's taken us, you know, we started this process months ago, last year, to get the revenues up in order to get a new loan. So one thing that's missing here is that we stayed open, and I meant to say this earlier, we stayed open for a purpose. I personally put a strategy in place that said, hey, we stay open, we can have our marketing team market so that when COVID is over, we're the only hotel that stayed open, we'll get the business, and then when COVID's over, we'll have great business. I don't know if it worked, I'm not going to take credit for it, but that was our plan. So COVID's over for the most part, knock on wood. Tourism is back, and we have way more business than we had before from staying open. We got all three airlines now. We have United, Southwest, and Hawaiian staying in our hotel every night. We have contracts with them. By staying open, the board, I think, is aware that we had the Love Island production crew come to the Big Island because we were open. We were able to bring in the Love Island production crew to stay at our hotel last summer before COVID was over. And it was a $10 million plus revenue generator for Hilo. We didn't get all that money, but because we were able to give the whole hotel to the production company, Hilo benefited, the state of Hawaii benefited from producing a show, but that's because we made a decision to stay open and still do sales and marketing. The Hilton Waikoloa couldn't get the contract because they were closed. We got the contract because we stayed open. Now the benefits of our revenues, a lot of people can point to this or that, and I'll just say, I'm not going to take personal credit, but we made a decision to stay open to try to market and keep the employees retained. And we have now been blessed by that. We have great revenues that are based on the great work of the employees in sales and marketing to grab the business when they couldn't go to other hotels because they were closed. So we are thankful that the employees had the success to get that business. So now we can say we have $6 million in revenues and be able to get a new loan. What's very important on reasonableness of in the private sector, I do want to give a comment that in the private sector, if you get a loan anywhere between 60 and 70% of the value of the property, in the private world, that's more than reasonable. Some people go to 75%. Some people go to 80%. We believe right around that 60% range is where we personally like our investors safe. So if we were to say this hotel is worth 95 million or 100 million or 105 million or 110 million, the appraisal, by the way, is 111 million. Okay, so if you take 62 million divided by the appraised value of 111 million, that's 60%, less than. When the appraisal was done for 111, Chris, and board, our revenues were only 4 million. So our revenues now are 6.5 million. What is the appraised value today? I don't have a number other than the last appraisal we have, which was 111, but we're in a very fair range. If it was a private, non-DLNR, it was a private owned property, 60%, 70%, very fair, very reasonable. So the board does need that in the record, that despite a subjective opinion that, well, we don't want to loan over 50% or 65, in the private sector, 75% is a reasonable loan. We're not at 75%. I believe we're 62 divided by, I'll bring the 111 appraisal down to, I'll bring it down, Chris, to say 100 million. So 105 million. We're right in that 60% range. Maybe it's 64%, maybe it's 65%. But the fact of the matter is we're not at an 80% loan to value. We're not at, you know, an outrageous loan to value. We have a very,
Move on to your next question.
Well, I have one last question about that $111 million appraisal. Who did that, and what was the purpose, and when, and what was the purpose of having that appraisal?
That was not our appraisal. That was Wells Fargo had done an internal appraisal on the property to give us our $50 million loan.
Okay, thank you.
Okay, other questions? Mr. Char.
Could you tell me a little bit about the lender, Hilo Hotel Funding LLC, what that is? And secondly, what provisions have they requested if this loan is consented to? What requirements will there be on mortgagee protection provisions?
I'll try to answer the first question. The second one might, you might have to brainstorm on that one because I'm not sure I could answer the second one. But the first one's easy. There was a company called Ocziff, which renamed itself as Sculptor, S-C-U-L-P-T-O-R, Sculptor. And they are a New York financing company. They're probably one of 5 big boys, girls that playing around in this game of giving big loans, $60 million loans, $100 million loans. And they have invested in Hawaii in the past, and they know Hawaii. They've been to the property, and you can look them up, Sculptor. I think it's just sculptorfinance.com. And it's a big lending company. The protections, I think the second question was protections of, are you saying the protections for DLNR? Is that the second question?
No, I'm asking what protection is the lender requesting?
The main protection is that they would become the, let's say I didn't pay them, that they would become the owner, and DLNR would then consent to them being the owner. So I think they're worth, I don't know how many billions. So you'd have a I don't want to quote what they're worth, but I know it's got to be over 20, $30 billion. It's a big company, and we're not worth that. So you'd have a better tenant than me. If I didn't pay the bill, they would pay the bill. So it'd be no different than Wells Fargo. If I didn't pay Wells Fargo, you'd have Wells Fargo if I let it go. You know, they don't not pay ground lessee payments. Big banks like that, you know, they pay what they're not going to lose the property. So you're going to have a very qualified entity in one of the biggest institutions in United States that does this.
Well, the reason I'm asking more specifically is that this looks like a specific Hilo Hotel Funding LLC, as distinguished from Sculptor or any other large lender. It looks like it's fairly limited in
They,
funding.
Wells Fargo, at Sculptor, a lot of these companies, when they do loans, Hall Finance, when they did the construction loan that you approved, the BLNR approved, when we did the Hall construction loan, they formed the SPE, the special purpose entity. So they have a Hawaii entity, a Hawaii LLC. They put the loan money into that, and that entity makes the loan. So they have a Hawaii entity because they're not authorized to do business in Hawaii. So they have to form a company in Hawaii to do business in Hawaii, and that's the way they elect to do it. I don't know why. But so they form a Hawaii entity that's owned by Sculptor and managed by Sculptor, and they fund the loan to that entity. And that is how, when we did the $20 million construction loan to build the Nani Loa, the same way Hall did it out of Texas when they gave us that loan. And it's called an SPE, Special Purpose Entity.
Thank you.
I don't know. It's to comply with laws or comply with something in the lending world. I don't know. I don't want to overstate what I know about that, but they do want to have a Hawaii entity be the owner.
I have a question of Russell, a couple of questions. So if I understand your case in a nutshell, it's that you're concerned about, if we consent to the mortgage, you're concerned about it going into foreclosure at some point in the future, 60+ million owed versus 50 million owed.
Right.
And if we, I want to walk through what the going into foreclosure looks like for our interests as the state. We are likely, if the property gets operated with a positive cash flow, there'll be a receiver, and we're likely to continue receiving lease rent in foreclosure. Then the property would be acquired by the lender in either case, and they would try to sell it to somebody. How are we, if we get our lease rent, then we have a question about who is the operator. We want to have an operator at some, and the bank would have to make a choice at some point of how much, perhaps, if they can't, how little they have to, if they have to take a haircut, if it's not worth a loan. How are we prejudiced by a greater amount being owed on the property?
Are we prejudiced?
Yes.
Yeah, good. Yeah, it's not a matter of being in foreclosure. We are in foreclosure. And we have been in foreclosure in the past. We have been through foreclosure and bankruptcy in the past. Mr. Bashore purchased this out of bankruptcy. Yeah. As far as the lender, if you're in foreclosure, both scenarios will take it. If they end up finding another buyer, the state has already consented to the new buyer. Yeah. And is being requested right now to do the same. Okay, in foreclosure, out of foreclosure. In bankruptcy, that may not always apply if it's not a foreclosure proceeding. However, the bankruptcy court has cram down powers to cram down the lessee. In this instance, you're not on the board at the time, Chris, but the prior board previously had a initial auction and had the winning bidder was actually the partners of Hilo Hawaiian. They went to confirmation hearing in bankruptcy court, and the court, then Mr. Bashore informed the court that he was willing to bid higher. And so the court opened up the bidding again, and then Mr. Bashore ended up getting the higher bid. The board at that time, the land board, actually did not consent to the assignment. And the court crammed down the lessee on the board. The bankruptcy court, whether you're at 62 million or 50 million, will have cram down powers against creditors, secured, unsecured, and in our case, we're the landlord. And they have extraordinary powers to do equity. That's the words of my understanding of the bankruptcy code, which means anything fitting that the bankruptcy court decides to do. So I think we have to face the situation. We're in it. We've been through it. We're gonna be through it again. The question is, what is it better? Is it better to have a $62 million debt on the real estate that we actually own, that is our property, at the end of the day, or a $50 million debt? And I say it's best to have a lower debt. At some point, if there is no buyers at all, it'll be a Chapter 7 conversion, and the liquidation would be free ultimately to find another lessee at that point. But that would be only in the context if there is no subsequent purchaser of the asset, whether in foreclosure or bankruptcy. I just don't think this is in the best interest of the state for further allowing the mortgage of the real estate, which is a public trust asset. Again, we're in a situation where it's red flags all over the place. It's pyramiding, borrowing to pay from Peter to pay Paul.
Well,
That should not be allowed. That
Yes,
should not be allowed. That's my opinion.
Well, the question, actually, the legal question, I am going to make a motion to go into executive session to talk with our counsel about some of these legal questions. So the legal standard is the consent shall not be unreasonably withheld. It isn't whether this is in the best interests of the state. That has to be on our minds, certainly, but we need to know that it's defensible. It will be a defensible decision as under that legal standard contained in the lease. But so what you're saying is, in either case, if you go into bankruptcy, if you go into foreclosure, if the foreclosure is finalized, we can end up with a new lessee that we never consented to, and we're just crossing our fingers and hoping for the best. And in a foreclosure, we still have to get our lease payments. In the bankruptcy, there's a possibility that the court could decide that the lease payments were unreasonable and order the lease payments reduced. Is that what you're saying?
It has crammed down powers and can do equity, is what I'm saying.
All right.
Now, let me get back to your other question, the reasonableness, unreasonable. It's laid out in my scenario, the scenario we have.
Okay.
The current loan is on its terms, whatever it is. We're being asked to approve a 2-year adjustable rate mortgage at over 12% in my calculation, it might be even more. Adjustable every 30 days. What that means is monthly payments can go up on the mortgage itself. Every 30 days in an interest rate climate that is skyrocketing with no end in sight.
And just
Is it
to clarify-
unreasonable? Is it unreasonable to
clarify,
deny it?
Russell, the mortgage would be secured by what?
A leasehold.
Only our
lease
interest.
term of the state.
The building and what? The mortgage?
And the right to be there for up until.
Let me ask my question. The hotel building and the WHR's leasehold interest in the ground lease? Is that right?
It is the leasehold interest in the ground lease for X term. And really what does
Will
that
be
mean?
mortgaged. So if that were foreclosed, then what happens to that?
They will try to seek, whether you're in foreclosure or in bankruptcy, the bankruptcy will go through a sale as well. They'll try to find a creditor or someone to step in to acquire it, to purchase it. Of course, In foreclosure, you're there to purchase it to pay off the existing lender, the plaintiff in the case. In bankruptcy, it'd be there to pay off all existing creditors. That's everyone, everyone. Landlord, tenant, investors, everybody. Obviously, creditors comes, the secured creditor would be in the first in priority. We would be considered a secured creditor to make sure that we get paid current, but we would only be getting paid our monthly payments, not so much, as long as if there's a willing buyer. And that's what happened in Mr. Bashor's case, where he took over from the prior bankruptcy, prior tenant, Mr. Fujiyama, Ken Fujiyama. But I was trying to say, I think that the question then becomes: is it reasonable or unreasonable to deny it? I don't believe it would be deemed unreasonable for the reasons I set forth in the submittal, is because of the situation we're in. It's a high interest rate loan in this kind of climate, in a foreclosure and bankruptcy situation. And it is not a threat of foreclosure, it is in foreclosure. So it is just a matter of moving it toward appointing a commissioner to go off and granting summary judgment to the lender on the amount, so appointing a commissioner for a sale. Otherwise, it might go into bankruptcy as well. Thank you.
Char, you're on mute.
Just some further background. I think if this matter went into bankruptcy, there would be issues as to whether the lease is executory, whether it would have to, what priority situation is. And it may, to some extent, from my experience, depend upon what the state is agreeing to in the mortgagee protection provisions, which I gather we've not had a chance to look at. So I think there's no question, as Russell indicates, that under bankruptcy, there would be powers of the bankruptcy court for cram down, forcing the state to undertake certain burdens, in addition to what the state is already willing to give up by signing this so-called consent that we'd have to take a look at. And I think those are other issues as to reasonableness if we were to pursue this consent issue. I have one other question area that I'd like to pursue from Mr. Bashar. Should I?
Yep, go ahead.
Okay, Mr. Bashar, two things. One, in items 2 and 3, we noted that there was lawsuits between the various shareholders or members of the Pure Limited Partnership. First question is, where are they with reference to this item 9 and the refinancing? Are all of your members in agreement to the refinancing that you propose? That's the first thing. And the second question I have is, you indicated that there was maybe $15 million that had been repaid to some of the initial parties that had got into the transaction. Is Olson one of the entities that got its money back? And for yourself or your entities, did you get some of that $15 million back also?
The details, I have signed a confidentiality agreement in the partnership documents that I'm not allowed to disclose if someone got $1 or 15. So I tried to be real careful and give you the flavor without, I don't want to come out of this hearing and have somebody, specifically say I said they got this and they got that. But I can tell you that to try to answer your question, I can answer it in a different way. The Olson settlement agreement has a let's say a washing of the hands, and Olson is no longer in the ownership upon execution of that and the closing of this loan. If we sign that settlement agreement, then Olson is not an owner any longer. So that should give you the answer to your question, but I don't want to give the details of what his financial exact numbers are, because he may not want me to disclose that. So you can call him and ask him that. I have no problem with that. But generally, a host of the members or partners that invested got their money back. When this loan is closed, if it's closed and approved by BLNR, then Olson would be sign a settlement agreement, because we want to sign that with him, and he would no longer. The members of WHR, the primary members of WHR, both agree to do this loan as in the best interest of the property. We think it's a very conservative loan. It's not risky. Some people would say it's risky, but I think a riskier alternative is not to do a loan. But that's just my personal opinion. I'm not going to say somebody's right or wrong. But I think I answered your question generally, that the members have approved it, and Olson is not in one of those members approving, because he would like to have a settlement and wash himself and no longer be partners in the ownership.
I'm confused. Are any of the loan proceeds going to go to Olson so that the entity will be able to take out the loan?
No money. I think I might have testified earlier to that. No money is coming out of the loan proceeds and going to investors.
However,
it's all going to the bank. It's all going to the bank.
If this loan is closed, is Olson still going to be a party to your organization? Will he be out?
No. The settlement agreement would end that. So the answer is no, he would not be.
I'm confused. So that if we consent to this loan, is Olson out?
Yes. He's not a partner anymore.
And out of the operating agreement?
Yes.
Okay, the other question was, you don't want to speak for
that's
Olson,
subject.
but
That's subject to everything being done. Yeah.
Yeah. Did you receive any of the 15 million?
Yeah, I invested originally and received part of the 15 million back in 2018. Yes, I did. I can answer for me, but I can't answer for other investors because I've signed confidentiality things.
Did you receive, can you give us a small, at least 50% of the 15 million, 10%, 2%?
Oh no, I didn't take a large sum. I would say it's $1 million or less.
Okay, thank you. Chair, at some point, I think we can continue asking questions, but at some point, I think it may be appropriate to have an attorney-client executive session so that we can be given further guidance on 2, 3, and 9.
Yep. I would happily entertain a motion properly worded.
So I will make a motion to go into executive session to consult with our counsel on our legal privileges, duties, immunities, obligations, and so forth.
I would second that, but I want to make sure the other board members have had a full opportunity to ask Mr. Bouchard whatever they wanted to. So I'm prepared to go into executive session, but
I'm good to go
I
in.
want to see if the others have any
That's a
further
second.
questions of Mr. Bouchard.
Member Canto, do you have any other questions?
I'm good. Let's go.
I do want to just remind the The consent that we're asking for is to be consistent with what the board has done in the past. So we're not asking for something different.
Okay, all in favor, say aye.
Aye.
I'm missing somebody. 1, 2, 3.
Uh-oh, where did Kaivi go?
Well, we got 4, so,
Oh, no, we need,
that-
I'm sorry, we need 5.
sorry, Kaivi, how do you vote? Aye. Okay, we're gonna go into executive session. Board members, let's take a short break so you can grab some lunch and we'll see you in the breakout room.
And roll call, I mean, that was all 5 members.
You, and that was Case, Yuen, Char, Kanto, and Yoon.
Thank you.
Thank you.
Thank you.
Keep going.
Do you know how long they're gonna take a break?
At least an hour. I always say at least an hour.
Okay. You gotta take off. So, out with you in a minute.
Yeah, I'd like to join. Hi, I think I'm in the main room.
No, you're still in the main one. Hold on. Trying to get her back in.
I thought you were an exec.
You have to go down and press join.
Um, hold on. Really? I'm in the,
Huh?
can
Did you
you,
press it?
hold on. Well, no, I don't have join. I'm in the main room with Polycon and Ed.
Here, wait.
Hi, Kaidi.
Hi, am I supposed to, is this the right room?
I don't think so. I just called Darlene. Hey, I'm not in the right room. Invite me to exec.
No.
So she's trying to do something,
Oh, okay.
I guess. Usually it has join da da da, but I don't see that.
Huh.
How are you?
Okay, how are you?
I thought we were on lunch.
Oh, here we go, here we go. Join.
You got the join da da? I don't. Okay, you're going.
Okay, I think we are reconvening here. All right. Just want to confirm that our AG is here also. Okay, we are back from executive session. We are on items D2, 3, and 9. Board members, are there any further questions or any further discussion?
Okay, they're talking, sorry.
Yeah, I have a question of Mr. Bouchard. What happens after 2 years? It's a 2-year loan.
We will either do one of two things. We'll extend the loan, or we will restructure and do a new loan for what I would call a insurance type of loan or a long-term loan, which in today's market, the CMBS loans that we would normally get for 5 years don't exist right now because of COVID. They kind of evaporated. And so what we got originally from Wells Fargo, we called Wells Fargo and they said, well, you talk to us in about a year from now to 2 years and we can redo your loan. So Wells Fargo loves us, has given me at least $150 million in loans. And they said the CMBS market, which this hotel is ripe for, would be available once that market opens back up. It's not open yet. COVID has ruined the lending world. So we think
what is CMBS?
we aren't going to even wait 2 years. By the way, Chris, we're going to start processing that probably next summer when the CMBS market loans come back into play. And those are lower interest rates, better loan terms. And when they come back into the market, then we'll do that.
What is a CMBS loan?
It's the loan that we did for $50 million, and it's a collateralized mortgage loan, which like the Wells Fargos of the world do on commercial real estate. Then they pool them and then put them in a security on the New York Stock Exchange. And so it's a CMBS is just a nickname for those collateralized mortgage loans.
Okay, let me say right now, my inclination is to make a motion to defer action on all 3 items, including the consent to mortgage. And the reason for the deferral on the consent to mortgage would be more information that verifies in writing the ability of WHR to support the proposed loan. And with the specifics of that worked out between the chair's office and the AG's office. And then after getting that information, hopefully we would come back in 2 weeks and consider this. According to the written submittal, there was an expected loan closing, I think today. And I was wondering if we deferred, is that an exercise in futility or is that a deadline that can possibly be extended?
That's a deadline that we didn't put in there. That was a deadline that the lender had put in there. I think the lender, in fairness to BLNR, had asked for a little bit more than I think they should have asked for. They asked for some other pledge interest, consent, and Wells Fargo never asked for that. And because of that, this I think got delayed with the attorneys, our attorneys trying to convince the lender to take that out, and the lender attorneys trying to keep it in. And so that delayed things a couple weeks, and that's why we got to here. The lender had given us that date that said if we don't close by the end of the month, we can't continue this forever. But that was when they were asking for in deference to you guys, I think they were asking for too much in that consent. I kind of sided with you guys that they were asking for too much. They definitely asked for more than Wells Fargo.
Okay.
And so the answer to your question is, we need to go back to them and say, the board would like, evidence of this income, that the project can support it, WH can support it. They wouldn't give us the loan if the WHR wouldn't support it, by the way. They don't like defaults. And so they've underwritten it that the property does support it. That's why they've approved the loan. But that'll give time, I hope, to get the consent worked out. But I guess I would ask that I have a question. Can you guys meet on that and look at that outside? Because the chair has the authority to approve the consent, but can the team of the staff look at that, what the lender submits and says why it supports a loan? Or do we have to wait till the 14th? If the lender says we got to close by the 8th or 9th and tells me that, then I'm really in a tough position. But if they supply that information in the next 24 hours, is there any ability to have the chair and staff and Russell and Kevin Moore look at it and say, yeah, the debt ratio is way above what it should support it. So I don't know if there's another little caveat that could be done.
What I'm actually not looking for I'm not looking for something from your prospective lender. We're looking for something that supports the assertions that you've made here, whether that's a financial statement or something that verifies that the profits of the Naniloa Hotel will support the interest payments that are projected for the loan as best that they can, and I'm not prepared then to say that we'll delegate it to the chair and staff to make a decision on final consent. So as a technical matter, I think if we can continue, just as far as this is not so much for you to know, but on a sunshine level, if we continue this matter, we can continue it to another meeting. We would continue it to the June 14 meeting and encourage you to submit further financial information. I'm not interested in your personal financial situation. You're not on the hook for the current lease personally, but something that supports the ability of the Naniloa to make the kinds of loan payments that are being proposed in this consent to mortgage.
We can get the financial statements, board, to Russell or Kevin, and get the financial statements that show how the success exists today, so we can get the last 12 months to you.
All right, so I make a motion to defer D2, D3, and D9 for the reasons stated.
Thank you. Is there a second to that motion? Second from Mr. Char. Any further discussion?
Yeah, I would, just for purposes of clarification, as a board member, I would like to review the restrictions or the requirements of the land board for giving consent. In other words, what is the lender wanting the land board to agree to in consideration for giving the consent and the mortgage? And I guess we already have a copy of the mortgage documents.
The consent document, I think the Attorney General and Cade Shetty, Cal Chase have been, or Nate Young, I believe Nate Yang have been negotiating those terms. So they've been talking for, I think, a couple weeks or a few weeks. Maybe it's only 2 or 3 weeks, but those drafts have gone back and forth.
I think we want to make sure we can see the loan documents also to ensure as Mr. Char was saying, the mortgagee protections, including any assignment provisions.
Okay. Yeah, whatever information you need, we'll be happy to provide to allow the right decision, without a doubt.
All right, then. Any other questions, comments, board members? If not, all in favor, say aye.
Aye.
Aye. Any opposed? Okay. All right. So D2 and 3
Thank you.
and 9 are deferred. Thank you very much.
Thank you very much.
Darlene, do we have anyone else in the, sorry, Russell, we might be skipping around here, in the boardroom to testify?
No.
Okay. Board members, anyone have any time constraints? Are you okay for right now? All right, Russell, why don't you go ahead then? I think we're at, let's see, we've done D1, 2, and 3, and 7 and 9. So want to go ahead with D4?
D4 was withdrawn, I believe.
Right, sorry.
Yeah, and D5 is, let's see. This is an amendment of a prior submittal for.
Well, so your microphone is, can you pull the microphone closer to your mouth, please?
The amendment is, this is an amendment to a prior grant of easement. Seeks authorization to issue 3 separate grants of perpetual non-exclusive easements to the city and county for drainage, flowage, and sewage. I don't have anything to add on this one.
Okay, any
Russ,
question?
I think I can barely hear you, so
Yeah,
maybe your battery
Russell,
or something.
You might need to just.
Barry, you
use
want
your
to take it, Barry?
Okay, I give it a try. Good afternoon, Chair and Board Member, Barry Chung, Land Division. Item D5 is an amendment of a former board action which grant some easement to the city and county. This is where the senior affordable housing project at Everly. After we got a board approval in 2021, when the staff was working with the AG and the city about the documentation, we learned from the city that they need separate easement document. So that's why we came here today. Basically, the purpose is the same, the area is the same, but the number of easement, we just have to increase from 1 to 2. That's all. I'm happy to answer any questions that you guys may have.
Move approval, Chair.
Second.
Okay. All in favor? Any discussion? All in favor, say aye. Aye.
Aye.
Aye.
Member Kent? Okay.
Aye.
Thank you. All right. Thank you. D6.
Barry, same thing, if you could take it. These are all.
D6 is a right of entry request for the Waikiki Rough Water Swim. Basically, it's the new event, and it's nothing different from the past years. So again, I'm happy to answer any questions that you guys may have.
Any questions? Thank you. Second.
Second.
All in favor, say aye.
Aye.
Aye, that passes. Okay, D5, D6, D7, D8 then.
Okay. Item D8 is a request for board authorization to sell remnant in Waimanalo. We came to the board a few years ago, and then at that time we were basing on the mistaken belief that the lot size was below the minimum lot size required by the board by the city. So we tried to argue that is a remnant. But the board then didn't agree to the staff recommendation. So we went back and do a little bit more research. What we found in today's request is actually there is no legal access to the state parcel. Even though on all kinds of maps, you see an easement designated zone or whatever you call marked on a map. But we checked all the title record, the deed, TCT, whatever. We couldn't find any easement either reserved or given to the state. So in my submittal, I was saying, okay, technically we can do a condemnation, whatever, to acquire the easement from the owner, but the owner is the applicant in this case. So I think it will be appropriate for the board. It will be the best interest for the board to relieve this housing stock and let the applicant buy this as a remnant. Thank you. That's all I have.
Okay, questions, board members?
Well, I was the one that objected the last time, and I thought that there must be some access to this, but it turns out that because it looked like it was created by some kind of subdivision action, but it turns out the historical background of it is really quite interesting and very much like another piece of property that's like this that came for sale as a remnant, the Dozopo Lima. And it does look like it doesn't have any legal access, and then it is quite small, although possibly somebody could put a house on it. So I don't have any objection to it now.
Okay, any other comments? If not, is there a motion to approve as submitted?
So moved.
A
Is
second.
there a second?
Yeah, second.
All in favor, say aye.
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 Okay, thank you very much. All right, I think that's the end of the D items, right? Okay, great. Okay, let's move back to okay, the C items, forestry and wildlife. Okay, David Smith, you want to go ahead with C1? David Smith, can you hear? And you're on mute.
Mute.
Yeah, there you go.
Okay, we're good. Okay, good afternoon. David Smith, Administrator, Division of Forestry and Wildlife. We have 3 items today. The first is request to approve and enter into a memorandum of understanding with the Division of Forestry and Wildlife, between the Division of Forestry and Wildlife and the Land Division, for increased collaboration assistance with approval by the Department of Attorney General. This is basically so that we can institutionalize the ongoing collaboration between our divisions. We've been working a lot on collaborating on multiple resource benefits on lands held by the department, and an ongoing discussion between the divisions on making sure that we're aligned on land uses and multiple benefits of department lands as it pertains especially to their leases and specifically to some of our grazing leases. So anyway, this is just sort of to institutionalize that relationship and to keep it going into the future. Made a lot of gains in the last few years. Just want to keep it going. The recommendation is to approve the draft, subject to the review of the Attorney General's office, and authorize the chairperson to sign the final documents. There's a draft attached.
Okay, questions, board members? This is, I will just comment that we're working on another one too, I think between state parks and lands. Hopefully you'll see that in the future. But, in the whole, make sure we're not siloed, and it is very, very interesting that, we have different Kuleana at the LNR in the different divisions. And but they do overlap significantly and in significant lands. So we want to make sure we have a formal way to make sure we are collaborating on those lands to make sure that we manage them as best we can for our public trust purposes.
Yeah, just a comment, Chair. I thought this was a weird one, but because I thought it was just policy or expected that they work together, but
Yeah.
Yeah, it is. I mean, it's an unusual approach is to have an internal MOU, but we have them externally. Our divisions have different responsibilities. And so, but they are, there are situations where land division may hold some land that is important for other purposes. And we want to make sure that we have a formal way of, checking in and reviewing all of those and working out where we need to be sure to be working closely together.
Got it.
Greg, can I ask
Yeah.
a question?
Yeah.
So there's nothing to involve Board of Ag, the Department of Ag on this submittal, right? Unless I'm not seeing anything, right?
This is only internal review.
Internal. Okay, thank you.
Any other questions?
Move to approve.
All right, is there a second?
Second.
All in favor, say aye.
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 I,
That passes unanimously with 5. Thank you. C2.
Okay, thank you. C2 is authorization of funding for the Nature Conservancy for $2.6 million during the FY 23 to 28 for continued enrollment in the National Area Partnership Program and acceptance and approval of the Waikomo Long Range Management Plan. Nature Conservancy is a long-term partner in our National Area Partnership Program. We've been funding a number of their reserves over the years. They actually helped us to get this partnership program established originally. And this particular area, Waikomo, has been, one of the landmark native ecosystem management programs in the state for decades, many years. And so it's a very long-running program. The state supports it. It's key right now to our management of KVQ, which we're trying to stave off the extinction of in the next few years. Nature Conservancy is a big partner in that. And so these come up once every 6 years. Last one was, I think in 18 was the last one that was reviewed or approved. And so anyway, the agreements are in perpetuity. The funding's on a 6-year basis. They have a new plan, which is attached. And so we're just looking for approval of the plan, authorize the match funding for the full 6 years, and authorize the chairman to negotiate and sign. And Emma Ewan is here if you got any questions, specific questions regarding the reserve or the plan. She manages it through our Native Ecosystem Protection Program.
I'll just make my disclosure I've made before that Nature Conservancy was my former employer, but I don't have any personal involvement or benefit from this.
Yeah, thanks, Dave. Or Emma, question. So what are some like 2 or 3 positive takeaways of having this zero-free ungulate zone?
I'll let Emma, you want to take a shot at, I'll just introduce Emma here.
Yeah, aloha. I'm Emma Ewan with Division of Forestry and Wildlife. I'm the Native Ecosystem Program Manager, and the areas that they manage in Waikomo, I mean, if you go outside the fence, it's just tons of pig diggings, and the pigs spread strawberry guava, make openings for a lot of clydemia and that sort of thing. So it's really important that we have this long-term fences put up, and we're actually really trying to also retrofit some areas, some fences outside of that to stop deer from coming into the unit now too. So that's a real huge focus, and this type of preserve will allow that long-term management to make sure the fences are checked, the weeds remain under control, and we continue to not see pigs and deer in this area.
Emma, can you also just mention the recent discoveries of with regard to rapid ohia death in fenced and unfenced areas?
Sure. On the Hawaii Island, there's been these incredible studies showing that in certain places, the rapid ohia death mortality rates are up to 64% or 64 times more mortality in a unfenced area that has ungulates versus a fenced area right next door, because it's hypothesized that the pigs and cattle and goats and all the ungulates in these areas are wounding the trees and making infection rates. So it's really just this even more urgent need to protect our native forests from these hoofed animals.
And last question, is there and thank you, it's all great work. Is there a sharing or educational component to this? Now that we have some longstanding data of what's going on, to help educate our public, the value of fencing in an area and controlling ungulates?
Yes, definitely. I mean, the Waikimai Preserve itself does community outreach events and has guided hikes and that sort of thing. But broader, we have just put up a story map on our website for fencing, which is a really good resource for folks to see the different places across the state that we are putting these fences up, and kind of see the inside and outside of the fence comparison and all the reasons we're doing this work. And yeah, we continuously are trying to find different platforms to make that case, because it's really important for the legislature and the general public and the federal government and everyone to know that this is the key to keeping our forests and our water supplies healthy.
Where
Thank
where
you.
would people find that story map?
It's on our website. I can put a link in the chat. I'm not sure if that goes.
If
to
you put it
everyone.
in the chat, I'll read it out when you put it in.
Okay.
Thank you. All right, any other questions? If not, is there a motion to approve C2 as submitted?
So moved, Chair.
Thank you. Is there a second? Second from Char. All in favor, say aye.
Aye.
Aye. Okay, that passes unanimously with 5. Thank you. All right, C3.
Okay, C3 is a request for approval for using a selection of a competitive sale proposal process, also known as RFP, to authorize the chairperson to award, execute, and extend contracts for the Enhancing Hawaii's Forest for Climate Resilience projects. So DOFA's received a federal grant from NRCS entitled Enhancing Hawaii's Forest for Climate Resilience. We will award approximately $4.5 million in this solicitation. And there'll be a number, opportunity to spread that money amongst multiple awards or multiple applicants. The funding is intended to support the planting of native trees. We're hoping for around 200,000 plus. Looking at carbon uptake, removal of invasive plants, benefits to upper elevation native forests, high potential carbon sequestration areas, and landscape scale watershed management priority areas. So the RFP allows us to solicit for proposals other than price. What we're really looking to do is proposals with the highest potential impact. There'll be an evaluation committee to select folks for this, for these awards. And so we're asking the approval of using RFP, establishing an evaluation committee, and to delegate authority to the chair to award, execute, and extend contracts for goods and services. If you have any questions, I'd be glad to answer them.
Okay, board members, any questions?
Move to approve.
Second.
All right, all in favor, say aye.
Aye.
Aye, that passes unanimously. And with 5, and I'm going to, I got the link here, but I'm just going to share screen real quick. And Emma, if you could just like, you said
Yeah,
click
scroll
on
down.
the,
Scroll down.
okay. So this
there's
is,
protect our water with fencing, that icon.
oh yeah, okay, protecting our water with fencing. Okay, I'll read out the link on it. But I just wanted to make sure the board members have a look on what this resource is in terms of outreach on the benefits of protecting our native forests from the damage from ungulates. All right.
Super
great,
cool.
It's a great resource.
Sure. Does
And-
do you guys allow these links to be shared on other websites, like partners websites?
Yeah, we encourage everyone to link to it.
Yeah. Well, I was just thinking, you know, organizations like, I don't know, Bishop Museum would be cool to have this kind of stuff on there. I mean, that'd be great.
That would be good. Emma, maybe you could follow up with Bishop Museum on that.
Okay.
I might know a guy. Nice guy.
Might know a guy. Okay, I'm going to read the link. It's https://dlnr.hawaii.gov/DOFA, DOFAW/education/learn/ and then you got all those icons that lots of good resources, and scroll down and click on the one that says protect our forests with fencing icon. All right, thank you very much for that. And thank you, DOFA.
Okay, thank you.
All right.
Appreciate it.
All right. Okay. Now we're going to move to, let's see, E, we deferred F. We're going to move to the F items. So that's aquatic resources. All right. Division of Aquatic Resources, are you here?
Yep, we're here. We've got 3 agenda items. Ready to start on F1?
Yeah, please do.
Okay, this is a request approval for a federally funded project agreement between DLNR and the Research Corporation of the University of Hawaii for a DAR research project entitled Hawaii Freshwater Public Fishing Area PFA Resource Monitoring.
All right, any questions, board members? No questions. Is there a motion to approve F1 as submitted?
So moved.
Second from Char. All in favor, say aye.
Aye.
Aye. That passes unanimously with 5. F2.
Okay, and Kathy Goecki, our aquatic biologist, will be taking the lead on this one.
Aloha Chair Case and members of the board. My name is Kathy Goecki. I'm an aquatic biologist with Division of Aquatic Resources. And today I'll be presenting item F2 for DAR. F2 is a request for authorization and approval to issue 2 Papahānaumokuākea Marine National Monument research permits to Miss Allison Fundus of the Ocean Exploration Trust for access to state waters to conduct seafloor mapping and to operate the exploration vessel Nautilus as a platform for various principal investigators within the waters of the northwestern Hawaiian Islands. And the applicant proposes to operate a 220-foot exploration research vessel within the monument to provide at-sea research an at-sea research platform to conduct seafloor map. Research scientists would work under a separate permit as part of the National Geographic Society expedition or other institutions' expeditions. And the ship will use a multi-beam sonar and a sub-bottom profiler to collect high-resolution mapping of seafloor characterization data within the expanded and original boundaries of the monument. And this is the same system that was used previously in expeditions conducted in 2021 and 2018 in federal waters or in the expanded areas of the monument. And additionally, the expedition will deploy an uncrewed mapping vehicle like a ROV that's also equipped with a multi-beam sonar that will map similar data, and also a National Geographic Society deep ocean drop camera that'll capture video of the seafloor. And I think the researcher is in the Zoom waiting room, Miss Allison Fundus, if you have any questions for her.
She is in. Ms. Fundus, did you want to add anything?
Not anything to add. Well, maybe one little thing to add. We also do a very robust educational program as part of these expeditions. We stream everything live and provide resources for educational use. And we also have an internship program, and we'll have a local Hawaiian student on board for some of these mapping expeditions.
Thank you. Any questions, board members? Not, is there a motion to approve F2 as submitted?
So moved.
Thank you. Is there a second? Second from you, and all in favor say aye. Aye. Okay, that passes unanimously with 5. Thank you. Have a great expedition. All right, F3.
Okay, F3 is a request for approval to authorize DLNR chairperson to enter into a contract between DLNR and InventTech Marine Solutions LLC for the purchase of a research vessel, $298,976.50 using Monsanto trust funds for the Division of Aquatic Resources, Maui Coral Reef Management and Monitoring Program. Happy to take any questions.
All right, any questions, board members? Sounds like everybody's in favor. Any motion to approve as submitted? It is kind of a Maui matter.
So moved, Chair.
Thank you. Second from Char. All in favor, say aye. Aye. All right, that passes unanimously with 5. Thank you very much. Good luck, everyone.
Bye.
All right, we are going to move to the J items. That's our last section here.
Hey, Pua, we're waiting for you, on these Maui ones. You gotta
jump
pipe in.
I'm thinking on that one, yeah, Chair, are they not called Bear now and not Monsanto?
It's it was a lawsuit settlement with trust funds that went to the Division of Aquatic Resources.
Okay.
So I don't know. That's how they came in.
Yeah. Okay. Thank you. Thank you, Kaiwi.
All right,
Anytime,
voting.
Maui.
Mahalo.
J, let's see. Which one did we defer? Okay, J1.
Good afternoon, Chair Case and board members. Finn McCall, our engineer, will be presenting the first 2 items.
Okay.
Good morning, everyone. Can everyone hear me?
Yes, sir.
Hi. My name is Finn McCall. I'm the engineering branch head for the Division of Boating and Ocean Recreation, and I'll be presenting items J1 and J2. So J1, this is a request to approve a planning project of ours to evaluate the impacts of sea level rise and tsunamis on our various facilities statewide. and to delegate authority to the chairperson to approve, procure, and award professional services contracts associated with this project. Like the title says, we're looking to get a more in-depth study done to look at the impacts of sea level rise and tsunamis on our facilities statewide, our small boat harbors and boat ramps, and have the selected coastal engineering firm to do modeling to look at these impacts, and then come up with recommendations and cost estimates for basically what we need to do in our facilities to address these issues. So I'll go ahead and open it up to any questions any of the board members have.
Thank you. Questions? Mr.
I do.
Ewan? Ewan?
Not Ewan.
Yeah, sorry.
Hey, Finn, this is something that I'm really interested in, sea level rise and its impacts. Is this study going to be dovetailed or, complementary to other sea level rise studies? Because, right, it's not one issue. There's multiple issues on our coastlines that we need to be aware of. And I just wanted to ask if, well, that's the first question. The second question is this the first assessment that the board is doing?
Sure. Yeah, to answer your first question, we're still very much in the planning phases of how we're going to tie this study into other studies that have been done. Of course, we're going to have, whichever consultant is selected for this to look closely at the other studies that have been done for the state. To answer your other question, no, we have not done any other similar studies like this for our facilities.
Can I add, we did, the Office of Conservation and Coastal Land did spearhead the effort to establish a sea level rise viewer, and that I would almost invert your question, Päivi. It's that is sort of laying the groundwork for many local studies to be done on specific facilities and vulnerable locations, such as DOBOR is doing now.
Yeah, thank you, Chair. I think that's, I thought it was OCCL, but I didn't want to say anything, but yes.
Yeah, absolutely. We'll want to coordinate as much as we can, with any other, especially local sister DLNR divisions and anything they've done, and any input they might have, we'll definitely incorporate that.
You guys won't need an MOU for that collaboration, will you?
I don't know.
It's just been a long day.
I think we need one with Bishop Museum.
Yeah.
Okay, any real questions here, board members? Okay, if not, is there a motion to approve? J1 is submitted. Mr. Yoon?
So moved.
Thank you. Is there a second?
So second.
All in favor, say aye.
Aye.
Aye. All right, that passes unanimously. All right, J2.
Thank you, everyone. I will also be presenting for J2. J2 is to approve a project at Nawili Wili Small Boat Harbor on Kauai to do improvements to our wastewater treatment system there. The item is also to declare our proposed project exempt from the requirements of HRS 343 to prepare an environmental assessment. And then lastly, to delegate authority to the chairperson to approve, procure, and award consultant and construction contracts and enter into any supplemental agreements or other agreements necessary to implement the project. The purpose for this project is because our current wastewater treatment system at Nawili Wili is being overloaded. And we are we're exceeding our discharge limits with the Department of Health. And we have been notified by them, and we have notified them of this proposed project. And the scope of work for this project is to do a retrofit into the existing system there. The proposed system that we're looking at is called a inoculator, a microbial inoculator generator units that they basically get submerged into the wastewater within the existing holding tanks that we have. And what it does is it kickstarts the microbial process that is already ongoing. Typically, in most wastewater treatment processes, they depend on the bacteria that's already in sewage to provide a lot of the breakdown of the organics that's in there. And what this system does is it adds additional agents and microbial agents that will basically speed up and increase the efficiency of the removal of organics and suspended solids in the wastewater. And by doing that, we can have our effluent from the treatment plant come back within our discharge limits permitted by DOH.
So Chair, I have a question. So does it supersede what's there now? I mean, what do you have there now that's not working?
Well, right now it's basically the system was designed for a smaller flow rate. We're seeing much more users at the harbor, so it's being overloaded, and the existing design of the system isn't treating it well enough to have the discharge from the plant meet the requirements of DOH. So the intent of this project is to retrofit what's there, add new units inside of the system that's already there that will increase the efficiency of the treatment process.
Okay, thank you.
Other questions? Okay, if not, is there a motion to approve J2 as submitted?
No, Chair.
Thank you. Is there a second? All in favor, say aye. That was a second from you, Wen. Unanimous with 5. Thank you. J3 is our last item. Recalling that we deferred, we withdrew J4 for now. J3.
Okay, good afternoon again, everyone. Ed Underwood, Administrator with the Division of Boating and Ocean Recreation. Item J3 is an administrative enforcement action against a William G. Friel III for utilizing his vessel as a principal place of habitation in the Alawai Small Boat Harbor without proper permits. For background information, Mr. Friel holds the mooring permit for the vessel in the harbor. However, there is also a co-owner on the boat, and her name is Huang Tran Fielder. Her husband is Will Fielder. And you'll see as we get into the submittal where that comes into play. So we have been for years been receiving complaints of people illegally living on their vessels in the Alawai and Cay small boat harbors. And we have been trying to deal with this. We even amended our rules to make it clearer on when a person can be on their boat and what they need to do to be able to stay on their boat overnight. So what we did is we reached out to DoCare and asked if we could enter into special duty with their officers to come help us at the Alawai, primarily on Friday and Saturday evenings when all sorts of activity would increase. And this has been going on now for since the end of last year. So we've been doing it for a while. So as this went on, as these sweeps went on,
Did you get the
DoCare,
material?
I'm sorry, is somebody asking?
Let me.
Go ahead.
Okay, so as this went on and DoCare was checking the harbor, they were also helping us check for illegal liveaboards. And in this situation, Mr. Friel had been warned about allowing people to reside on the vessel without proper permits. So on 6 different occasions, as in the submittal states, DoCare visited the vessel, and all indications were there was an individual residing on the boat. In fact, we believe William Fielder, his wife, the co-owner, his wife, and also a child and a dog. So DoCare, DoCare's here, they can provide their perspective on this. So when they visited the vessel, often what happens is they'll knock on the hull of the boat to see if anybody's there. What they heard was dogs barking, commotion on the boat starts rocking back and forth, and then all of a sudden the dog stops barking and nobody responds. And this happened numerous times, at least 6 that we know of. All indications are they are living on the boat. Other people in the harbor have indicated there's people living on that boat. So what we're bringing this enforcement, this is the first one we're bringing before the board. We feel we really need to do something strong to send the message that people should not be living on their vessels without proper permits. So we're asking the board to find that on each of the 6 different occasions is look at it first offense, separate offense, which is $5,000 per offense. So to assess a $30,000 in total fine for using the vessel as a principal place of habitation without a valid permit. We're also asking that the board revoke the use permits issued to Mr. Frio, which include the mooring permit and the any associated other use permits. And then also prohibit Mr. Frio from obtaining any new use permits for a period of 24 months, 2 years. And I can answer any questions you may have. And again, as I said, the DoCare officer is here to testify as well.
Thank you. And Mr. Friel is not here, correct?
He apparently not. We sent him for the first meeting, which was going to be held last week, certified and regular mail, letting him know about this. We also sent it again, certified and regular mail to him about the meeting. We never did hear from Mr. Friel.
Ed, where'd you send that mail to?
All his known addresses and the address that he has the vessel registered to.
Okay.
So we checked vessel registration and what we have on file at the harbor as well.
So he does have other residences, is that correct?
I believe he doesn't live he lives in an apartment or a house somewhere. That's where we sent the notices.
I see. Okay, thanks, Ed.
Sure.
Mr. Char?
Yeah, I'm somewhat confused. Who is Eric Alpert as distinguished from Mr. Friel?
Mr. Alpert was going to be in item J4 that we withdrew. He indicated, we got an email from him this morning that he didn't have time to get his attorney in place. He said he couldn't get the attorney to make the meeting today, so that's why we deferred the item.
Okay, I guess I'm confused because in looking at the materials from J3, there's a lot of Alpert stuff in there. And I was a little confused.
That could be as part of the DoCare reports when they found multiple people on board. That's probably what you may be looking to. But item J3 is specific to Mr. Friel.
Okay. And, you know, I gather the testimony is that they would knock on the boat. Did they ever find Mr. Friel on any of these occasions? Or is it just their suspicions because the boat moved and the dogs barked? Did they ever confront Mr. Friel?
Mr. Friel was not seen on the boat. What we found is it's the co-owner of the vessel, Mrs. Fielder, and her husband and child were on the boat. DoCare, one of the major issues we have is DoCare can't enter the vessel. We are in discussions with our deputy AGs on whether it's permissible if we suspect somebody's just not answering us when we're at the vessel, whether they can actually go into the vessel. And there's some concern with allowing them to do that. So it does make enforcement difficult. The reason why Mr. Friel is named is because he is the permit holder.
Okay. So have you ever met Mrs. the woman? This one. Has there been any confrontations with these people that you're charged?
I would probably defer to Docare on that and what they've saw. I think Officer Pang is here.
Officer Pang, are you available? And if so, you are on mute. Officer Pang.
So if I could add, Chair, on page 4 of the submittal, the first paragraph, the Docare officers initially encountered Mr. Fielder on the boat, William Fielder, who is the husband of the co-owner.
All right, Mr. Char, do you have any other
Yeah,
questions?
I guess I'm reading page 4. So there has been a confrontation with William Fielder then?
Yes.
And was this, was there an acknowledgement on his part that he was living on board the ship?
I believe so, yes, but I was not there, so I couldn't give you 100% on that.
Yeah.
We're looking through the reports now to see if we can find that.
Yeah, because I noticed in that page 4, you found a motorcycle belonging to him at the dock. The porthole covers were closed or open. You heard a dog bark. And you announced your presence, but for $30,000 in fines, I was wondering if there was more evidence than of someone actually living on board the boat besides these the dog barking or the bike there, that kind of thing.
So on page 3 of the Docare report is Exhibit B. That between the hours of 12:15 a.m. and 3 o'clock a.m., Docare did contact Mr. Fielder on the boat. He's not the registered owner. We have from testimony of people in the harbor itself and all the other evidence that we found, it suggested very strongly that they have been living on the boat for some time now. And that's why we brought.
You're referring to Exhibit B?
Yes, Exhibit B of the Docare report. It would be page 3. It'd be about midway down the page.
Okay. Okay, I see that. Thank you. Yeah, because that's where I was confused on page 2 of that talks about Alpert, and so I was. And the next page is 3 was also Alpert. Okay.
Yes, that's a report of what they found that night and who they found on their boats.
Okay. Fine, thank you.
Okay, other questions? Mr. UN,
The submittal says AJR 13-231-28A prohibits staying aboard any vessel except when you have a written notification in advance of the intended stay aboard date. Staying aboard a vessel for more than 3 nights a week is prohibited except where the vessel owner has obtained a valid stay aboard permit from the department in advance of the intended stay aboard period. Does that mean that you can stay for 3 days without getting a stay aboard permit?
No, I don't believe so. I believe you need to have the stay aboard permit to be on the vessel for up to 3 days,
Okay,
not to exceed 120 calendar days.
okay,
in a
so
year.
you can, you have to get a permit to stay 1 night?
Yes. So we went through this some years ago when we were amending the rules, because what happened when we were doing the suites back then is people said, oh, I put in a request for a stay aboard. And we said, well, where's the request? We have no notification of it. So then we said, okay, as long as you even slide a piece of paper under the office door that says, hey, I'm staying on my boat, I got in late or whatever, we would accept it. Harbor office checked, we checked with staff. There was no notifications at all that they had given us notice that they'd be on board the vessel.
Okay, just give me a minute to double check the exact wording of that. And I'm gonna believe you, but I just want to see what the exact wording is in the administrative rules. And, you know, we can go ahead with other questions if there are.
Oh, while we wait for Chris, Ed, were you being facetious about sliding a note under the door?
No, that's what people said they do. So we would accept it. If you even slid something under the door, we'd say, okay.
You slip a Post-it under the door and somebody steps on it, stuck to their shoe.
That,
won't get it.
Okay, I read the rule and I see where it says what you're saying. So it's easy to get permission to stay for 1 to 3 days. And this guy didn't do it.
He did not. And we notified him over and over again that you can't do this because it's a rampant problem in both, mostly the Alawai Harbor, and in the Ke'ehi small boat harbor.
Okay, I'm okay.
other questions, board members? Okay, there is no public testimony on this. Does somebody want to make a motion on J3?
I'll make that motion.
To approve the submittal as submitted, J3 as
Approve
submitted?
staff submittal.
Okay, is there a second?
I'll second.
All right, any further discussion? If not, all in favor, say aye.
Aye.
Aye. Okay, that passes unanimously with 5. And again, a last vote, the 5 are Case, Yoon, Kanto, Char, and UN. Thank you very much.
Thank you, everyone.
All right. Board members, Darlene, everyone, that brings us to the end of our board meeting. Really appreciate everyone's flexibility and perseverance on a long meeting that had to be rescheduled at the last minute. So really appreciate it. And we will look forward to talking with you soon. And AG, thank you, AG. All right. Take care,
Bye.
everyone.
Good day,
Bye.
And
everyone.
would you clarify, we have a meeting tomorrow morning at 8 o'clock?
Yes.
Wait, what? We have a meeting tomorrow?
No, it's our argument in the
I mean, they're
contested
all
case.
arguing. It's 8 o'clock on Zoom.
Yes,
And then Friday
noon.
at noon. Also both on Zoom and both hearing. Okay.
Okay,
Thank you.